Hey, Carrie.
Hi, good morning.
Good morning. What cases are you handling today?
So I don't have personally any PCCs until 9:45,
Okay.
but I'm zooming in on behalf of Mike Woodyard, who's
For
in a
Miss
trial.
Barrett?
Yes.
Okay,
So
I literally just hung up the phone with him. So I am just confused about, I have Tyrone Bickert assigned to that case. Is it supposed to be Woodyard or is it Bickert?
I believe it's Woodyard.
Okay. All right. I will let Mr. Bickert know, but I am adjourning it out the 8 weeks for the forensic center.
Okay.
And I will send new notice to Wayne County Jail just to give them the heads up on that. Okay?
Okay, great. So no need to go on the record for that one today?
Nope, nope.
Okay, great.
So you're gonna zoom in at 9:45 for your Emery case?
Yes, I have Mr. Emery, and then at 10 o'clock, there's Miss Lewis, who's zooming in from MDOC. And then finally, there is a Kane Kelly, at 10:15. That is Woodyard's case, and I will cover that one.
Okay, perfect.
All right, thank you. And I guess
Thank you.
maybe it was a Tyrone Bickert case, and Woodyard had said he would cover for Bickert. Now Woodyard's on him. So I really don't know.
Well, I'm just
Don't
thinking
quote me
that
on it.
Woodyard must be covering her in other places because he knows all about different things that's happening with her. So
Okay,
I'm not sure. So I'm thinking that's what's going on. So he wants me to let Mr. Bickert be aware of what's going on with the case.
sounds good. Yeah, just didn't want you to quote me on that when
Yeah,
I really
that's fine.
wasn't sure. All
All
right,
right.
thank you. Then I will
Thank you.
do back in at 9:45 for Emery and those other ones.
All right. We'll see you then.
Thank you.
All right. Bye-bye.
What just happened?
Mr. Zamet, just hang
Yeah.
tight. We haven't done your case yet. We don't have your attorney.
Thank you.
Unless your name is Rebecca Barrett, who we just discussed. Okay, you're good. You're
Thank you.
good.
I'm making sure. Thank you.
Yeah, you're fine.
Thank you.
Hi, Mr. Reed.
Yes,
You're here on Kelly Kane,
yes.
and are you filing an appearance?
We did file an appearance. I got discovery and everything.
All right, because
I mean, that's all I could do. I filed the appearance. I wouldn't have
I
got the
understand that, but you're not in here as the attorney. And so that's why
Okay.
I'm wondering,
Okay.
let me go pull the file.
All right, sorry about that.
And
Yeah, I'm on the.
this case is at 10:15.
Oh, okay, I didn't know. I thought it was 8:45.
Who did you file an appearance with?
Well, I mean, with the court somehow I got the copy of my appearance here, but I'm on the road, so
Okay, so your appearance was never filed with us.
it was.
So, okay, well, we haven't received it, and today is an in-person hearing. At 10:15, if you're able to be here at 10:15.
No, I am not able to be there at 10:15. I didn't know it was in person. I thought it was Zoom, and it was 8:45. That's what I was told. So, our client is gonna walk in. I know they'll be there at 8:45.
Okay, so he knew it was in person.
Oh, did he?
Well, if he's gonna walk in, then he knows that it's in person.
Oh, okay. All right.
All right, let me go follow the file and see if we have your appearance.
I appreciate that. So, what is this for? So, uh, okay. I think you told me enough.
Just,
File for certificate.
Oh, okay. Mr. Reed, what were you gonna do with your case today?
Yeah, we're gonna have this matter sit for the exam.
Okay, well, we'll wait till your client gets here and then I'll let the judge know and then he can come out and we can set it.
I really appreciate it.
Yeah, but your
Thank
client's
you.
not here as of right now, just so you know.
Okay, thanks a lot.
Just so I know, you're not referring to me when you say the client, right?
no, he's not your attorney.
Okay.
Mr. Bickert's your attorney. Yeah, no. We'll call you out. We're waiting for Mr. Bickert.
Mr. Reed? Mr. Reed? Jelani? Jelani? Mr. Robinson? Hello?
Yeah, it's on there.
Mr. Robinson? Jelani Robinson. All right, goodbye. Oh, I meant to delete him.
Heather, you want me to take him in a breakout room? and talk
No,
to
I want
him?
to know why he's on Zoom.
Oh.
Mr. Robinson?
Yes.
Why are you on Zoom?
Oh,
Your hearing's
Um,
in person today?
okay. My lawyer sent me a letter telling me that it was on Zoom. Okay, I'll make my way down there now.
Okay, thank you.
Okay.
Mr. Reed?
Here he gets
Yes.
Have you spoke to, I mean, does your client live in Jackson?
Yes, he does.
And your client's driving here today?
Yes, he is.
All right, thank you.
I was trying to see if he could put your viewers on just to set it for exam, that's fine. But if
I
not,
think that
then-
that would be easier, instead of the defendant driving all the way from,
Okay, I'll tell him to log on right now.
thank you.
Hey, Heather, who's our MIDC?
Mr. Bowditch?
Oh, okay.
Yeah, so cross your fingers, we won't need him on Zoom.
Yeah. There's Mr. Kelly.
Yeah, I didn't want to grab it without asking somebody. Should be a driveway suspect.
Michelle, are you taking him in?
Yep, yep,
Okay, thank
I
you.
got him already.
No. I agree.
What time's Kelly's scheduled for?
10:15.
Oh, okay, no wonder I can't find it. Counsel on Ward, your appearance, please.
Good morning, Your Honor. Thomas Strappin on behalf of Pleas Contracting.
Good morning. And you have corporate authority to take care of this?
I do.
And tell me about the deal.
It is reducing it to a civil infraction with the understanding, as I understand a lot of additional points associated with Mr. Ward's record, because it was a commercial record. I mean,
Okay.
because it was a commercial vehicle that it had a
Okay.
registration.
All right. And Mr. Ward, that's the way you want to take care of this today?
Yes, Your Honor.
I'll accept your plea to the civil infraction. I'll dismiss the misdemeanor that was issued on April 25, 24. Fines will cost $200. Can we cover that today?
I will cover that on behalf of the company.
Okay. You know the company's name's not on this ticket.
On the circumstances under which this happened. it is
Okay.
the company's responsibility.
Okay. All right. Got you covered. Downstairs, cashier will smile when she takes your money.
All right, thank you, sir.
Have a good day, gentlemen.
Very much appreciate it. P74345.
We'll send it down. They'll be ready for you when you get down there. Kelly? Can I have appearances on the People versus Kane? Kelly, please.
Yes, good morning, Your Honor. Happy New Year. I haven't seen you all year.
Good morning, Mr. Reed.
Good morning. Attorney Daniel Reed appearing on behalf of Mr. Kelly.
How you doing, Your Honor?
Matter proceeding by
Good.
zone. Mr. Kelly, could you state your name?
Kane Kelly.
And I've also got another box that has Kane Kelly's name on it. What's going on with that one? Mr. Kelly, you got a camera?
Yeah. It's not on
Go ahead
yet.
and activate.
Hold on.
Thank you.
Oh,
Mr.
sorry.
Reed, what are we doing today?
At this time, Your Honor, we request this matter be set for a preliminary exam.
All right, I've got 3 dates I'm looking at: June 5, July 10, or July 17. All afternoon, late morning or early afternoon dates.
All right, I have a 1:30 on the 5th. I was coming in the morning. I didn't know this was not an afternoon. What's the earliest we could do it on the 5th?
11:45.
Yeah, I think that would work, Your Honor.
All right, we'll put you down for 11:45. Mr. Kelly, that's live at the 34th District Court.
Say
And
yes,
I will
sir.
continue bond.
Oh, yes, sir. Yes, sir. Sorry, I was writing it down.
Bond continued, counsel.
Thank you, Your Honor. We appreciate you. We'll see you on the 5th.
You gentlemen enjoy your day.
All right,
Thank
you
you,
also.
too.
Be safe.
Yeah. I can't get people out of the meeting room.
I can log out or wait
You
around.
can, Mr. Kelly. You're all set. Enjoy your day.
All right, thank you too.
Okay.
Thank you.
We're just adjourning the PCC?
Yes, can I have 2 weeks out, Judge? Next
Sure.
Monday, I start a murder one.
Yeah, no problem.
Appreciate it.
So you want the 12th?
Beautiful.
And Mr., is it Tonda?
Yes, sir, Your Honor.
We've got a impeding traffic ticket here that you owe money on. You know about that one? From 2023, looks like Romulus issued the ticket.
Yeah, I was making payments on it.
Are you behind on payments?
Yes, Your Honor.
Can you get back on track?
Yeah, I'm giving a couple weeks. I've been caught up.
All right, I want you to go downstairs before you leave and make arrangements with our payment people. What's that?
How much do I owe?
Our paperwork says you owe $236. What time you want?
Oh, 8:30 is fine.
8:45?
8:45. What day, Joe?
12. And that is with Judge Green. So that'll be Zoom.
That'll be Zoom. Excellent.
And I'll continue bond.
Thank you so very much, Judge.
You're welcome.
A lovely day to you and your staff.
You as well. Mr. Tonda, we're gonna get you a paper notice.
Yes, yes, sir. Thank you, Your Honor.
You're welcome.
And I'll send you those letters. Yeah. Never do. Good morning, how are you? No magical way I can.
Oh, whatever.
I can text him and ask him his ETA.
Oh. Mr. Tonda, I misread this. You only owe $36.
Oh, phew.
Your Honor, I would pay it right now, but I'm still trying to get my money.
No, just make arrangements to get it taken care of. We want to close that out.
Thank you. There it is. And you're free. Yes.
Thank you.
Absolutely. I'll mention it. Just give me a hot second to figure out what is happening with a code worker. Of course. The name of the gentleman who's been on the screen.
This is Mr. Zaman.
Okay. Can I help? He's getting antsy. He just likes to help. Well, for an hour. Oh, heavens. Let me see if there are any notes on the gentleman, so I know what I'm doing with him, other than obviously being brilliant. As usual, we would expect nothing more. Zero notes.
You want to?
It's a
Are we-
PCC, right? Correct. And I think all we're doing is setting an example. But now, Mr. Bickert's not here, we cannot set it, he, as you see, does not show up. We will need to make sure that his calendar is, unless you're gonna take it. I have his calendar, does that work? He's supposed to be here. Yeah, I don't know, I mean.
Council, that's the problem. I've gone around and around with Mr. Bickert. I like him. He's a nice guy. He just does not show up. And if he does show up, he's always late.
Heard.
So if I give him an exam date, that's gonna be his date, his time. I'm not gonna have a bunch of stuff scheduled at the same time. I'm not gonna stand here twiddling my thumbs if he's not here on time.
Your turn, Judge. I was just hoping that.
Oh, and I appreciate it.
Understood. Well, let me see if Mr. Bicker got back to me about it today. I spoke to him, I think, last week, and he assured me that he would be here once he got his child up. Yeah. Texted me, he's pulling in. He's pulling in, good, okay. Okay, then. You guys find out in Halloween. Then I'm out of your hair.
Thanks for the offer.
No worries. To get on Zoom because there's a guy that's been waiting and that's who he needs to speak with first.
I think Michelle needs him for one too.
It's the same one. Yeah, so once he jumps on, Michelle will throw them in a breakout together.
All right.
Thank you. Have a good day. Nice seeing you. Very nice to see you.
Mr. Zaman, it looks like
Always a
it's gonna
pleasure,
be
Counsel.
quick. Your attorney is just pulling into our parking lot, so it should be quick.
Vicar is here. Okay. Yeah, that's what he's doing right now. The sign we told him to do him first. He's here.
Good morning, Mr. Bicker.
Hey, I'm so sorry. I'll explain a little
It's
later.
okay.
I'm,
Let me get you in with Mr. Zaman, okay?
Yep,
Do
yep,
you
I'm
need to
ready.
talk to him first?
Yes, I'm
Okay,
ready.
let me put you in a room with him, okay?
Thank you. Yep.
You're welcome.
And then what's worse, then the jail's got to do it, right? He's on this off of his chart. You know, more than jail. Just by grace of God, we determine to fight this point, so we get hurt. Why? Because it's become a lot of the Zoom class.
Yeah, our 11:30 was originally. For a while, and so I think it's not awkward. Oh, it's not awkward. And she's coming in, but I think I farm her, but she's been still trying to like emotion on the yeah. And she's just taking over. She's just saying, yes, I agree with you. Yeah, well, she got emotion. Yeah.
Nobody in the world would say, wait a minute. And one
No, I just make sure that you're on.
Hi, Judge. Good morning. What's your client's name?
Juwan Thomas.
Okay, one at a time.
Juwan Thomas.
Thank you. Counsel, go ahead.
Good morning, Your Honor. For the record, Sterling Coleman on behalf of Juwan Thomas. Judge, I'm not sure if this is an arraignment on the warrant.
I think it's an arraignment pretrial.
waive further reading, acknowledge receipt of the complaint warrant, waive same, stand mute.
All right, so let's see what we got for a plea agreement. Failed to display a license, DWLS will be dismissed. And civil infraction registration 257.255, misdemeanor registration and plate charge dismissed. That's it?
That's correct.
Okay.
That's how we wish to resolve this.
All right. Sir, did you go over your rights with counsel today?
Yes.
You understand those rights and the options
Yes.
they give you? Why are you sitting here? Do you not think we can handle this without you? Go back to work. Get me some files in here, Mr. Mohammed. Chop, chop, let's go. I just love that kid.
Yeah.
You know, when he first got here, you know how they send these baby prosecutors out with no training?
Yeah.
He didn't have a clue what to do. He had no clue what he was doing.
He's gonna learn quick.
He is learning quick. And you know what I like about him? He's humble. You can go to him and say, look, I'm just trying to learn, Judge. You know, a lot of people don't know what they're doing, but they're not humble about it.
I know.
He's humble about it. So he's going to be a good prosecutor. I think he's already a good prosecutor. All right, so back to business for Mr. Thomas. So you've gone over your rights. You understand your rights. Do you understand the possible penalty for these charges today?
Yes.
All right, understanding that, are you pleading guilty to these two charges freely and voluntarily?
Is it responsible or guilty?
Responsible to one, guilty to one.
Yes.
All right. So did you drive a vehicle in or on April 19, 2024 at a location near I-94 and Wayne Road?
Yes.
All right. And at that time, did you have a valid license to show the officer that stopped you?
No.
Satisfied with that plea, counsel? And you're pleading responsible to the registration violation, civil infraction?
Yes.
I'll accept that one. I'm going to dismiss both of the original charges. And Mr. Coleman, what should I know about Mr. Thomas before I sentence?
Well, we're trying to get him back into a place where he is fully rehabilitated. He's got a pretty good ongoing business, you know, so.
What's the status of his license now?
Well, what we're trying to do is, once the driving license, DWLS gets dropped off, it's my understanding, he can virtually reapply. He's had.
Good.
That's what we're
Good.
hoping, because,
Good.
you know, if he's convicted.
So we think he's close.
We're close.
Okay, okay.
Close.
And what do you do? What do you work?
I gotta ask for a paper business.
Oh, you're busy right now, aren't you?
Yeah.
Good, good.
And he does.
Yeah,
a
so
lot
you gotta pay somebody to drive your butt around.
Yeah.
Right? You're paying somebody to
Yes.
drive you around,
Yes.
right?
Yes.
Okay, okay.
Yes.
All right. Okay. Anything else I should know?
No.
All right, on the no valid operator license on person charge, fines and costs total $500. On the registration civil infraction, fines and costs $200 for a grand total of $700. Do you need a payment plan on those, sir?
No.
You want to take care of that today?
Yes.
All right, go on down. The cashier will smile when she takes your money. Good luck on that license.
Okay, thanks a lot. Thank you again, Your Honor.
Always a pleasure, counsel.
Likewise.
The plea through or what? Or maybe there's somebody out there you don't want to talk to.
Or downtown, he has to hang out.
He worried about that. They don't know ways for them.
Right.
I would expect, I mean, if I was in the prosecutor business, I'd want to review a new guy, not after this long, but, you know, I'd want to see what he did on every file, just to see if they were reasonable, if they looked odd, and explain what. I would want to watch what he's doing in court. Especially in a plea. Have you ever watched these videos on YouTube? Customers
No, the way they bring the cars into dealerships and stuff like that. No. Oh my God, you gotta watch it. Customer states, car makes phone noise, it turns to the left. You know, realize there's something hanging on that steering wheel, so he turns off, it's like, well, there's something, just stupid stuff. Or, you know, they'll bring it in for an oil change, and then they'll show you that pull the plug out, and the oil comes out close. Like $150,000 miles on this car. Just crazy stuff. I'm like, oh yeah, I had a car. That's okay. Check with that together.
Yeah, I understand that they didn't because of.
Yeah, that's not. Part of the chaos. Yes. Here's my guy.
Come on up, gentlemen.
This is Mr. Douglas. Judge finds a file.
Rivera Doblas. All right, your appearance.
Your Honor, for the record, Jeffrey Bowditch, appearing on behalf of with Mr. Douglas. Sir, could you tell the judge your name for the record, please?
William Rivera Douglas.
Good morning.
Thank you, sir. Your Honor, today's the date and time set for hearing in this matter. We read it and stand mute. We've also had a chance to pre-try this case. We have an executed plea agreement subject to court approval. In that agreement, Mr. Douglas would plead guilty to the charge of allowing an unlicensed driver to drive a vehicle with the understanding the original charge would be dismissed.
Thank you. Sir, did you discuss your rights and options with Mr. Bowditch?
Yes.
Do you understand the possible penalty for the added charge today?
Yes.
Understanding that, are you pleading guilty to the charge?
Yes.
Are you doing so freely and voluntarily?
Yes.
Did you drive a vehicle in Romulus on March 13, 2024? Did you have a driver's license that was suspended, revoked, or denied?
Yes.
I will accept your plea to the added charge. I will dismiss the original charge.
Thank you.
I see he's got a valid license now.
Yes, sir.
Awesome. Where do you work, sir?
Saboni Cement.
What do you, cement?
Yeah, cement.
Okay, how long you been with the company?
11 years.
Good, good. Pretty busy right now?
Yes, sir.
Good, good. Anything else I should know before I sentence?
No.
Nothing.
Sir, fines and costs total $500. Can you pay that today or need a payment plan?
I'll probably pay today.
Okay, you can take care of that downstairs.
Yes.
Have a nice day. Thank you, Mr. Bowditch.
Downstairs. Are you going in your office?
Would you bring me a couple pens?
I
Thanks.
have them in here.
Do you?
They're in the.
All right, Mohammed just wants to adjourn this a week. Mr. Chair, we'll get you a paper notice to come back in a week.
Okay, will I get it from out there?
Right here. She's gonna get it in just a second.
Hey, Josh, we don't have your client yet.
Okay, we're doing a civil, so I don't know if you needed them or not, but I'll tell them to log in now.
Do you already have the plea?
Yeah, it's I sent it to Heather last night. It's just a civil infraction registration plate.
Okay, hold on. Judge Josh Kaplan's here on Joseph Duff.
Dealt with a D.
Duff.
Duff. All right, got it. Counsel, your appearance, please. Good morning.
Good morning, Joshua Kaplan on behalf of Mr. Duff. And I do have authority to enter into this if you'd waive the personal appearance to a civil infraction registration plate.
Yeah, I'll waive his presence. I'm trying to figure out the plea. So what are you pleading to on his behalf?
We're pleading to a civil infraction dismissal of the misdemeanor.
Yeah, I figured it out. 257.255, yes?
Correct.
Okay. And was there any discussion regarding fines and costs? Was there an agreed upon amount?
Discretion of the court.
Would you believe that we've been rubber stamping everything with the wrong date?
I can't believe that.
Holy cow.
And then with you.
All right, I will accept your plea to the civil infraction. Fines and costs, $200. How much time do you need to give your client to get in here?
14 days.
Done. All right, that'll take care of it.
Thank you very much. You guys have a wonderful day.
that's gonna reflect poorly on somebody's job eval. Just don't tell Tim, Heather. Find it? Which one you got? 4. What are you doing with it?
Prosecutor wants to see it.
Oh, okay.
I think it's.
Thanks.
Hey, Heather, do you see Mr. Bickert somewhere?
I noticed that. It looks like he signed out.
If we could at least get him in the courtroom, let me see if we can find him.
I'm just wondering how it ended up here when it was just supposed to.
Heather, they're sending him into the courtroom.
I will just get this exam date. Should I do that? My clients on Zoom?
What do you got?
We can handle while you're in.
We're gonna just set exam it for exam.
Fellas, go ahead and put your appearances on the record.
Wayne County, we need you to turn your camera back
Sure.
on.
Good morning.
Good morning.
Have you guys discussed the date at all?
Me and the defense attorney, no. I think the next time is in 1 month, right? 6 weeks.
Yeah. Mr. Bickert, your appearance?
May it please court, Your Honor, Tyrone Baker, appearing on behalf of Mr. Salmon, who's present via Zoom, Your Honor. Good morning.
Mr. Zamet, can you hear us okay?
Yes.
All right. And gentlemen, you want an exam date?
Yes, Your Honor, I respectfully request an exam.
I'm looking at June 5, July 10, or July 17.
Your Honor, I believe I have here on June 5. I'm trying to double check that right now, Your Honor. I apologize.
Go ahead.
Oh, okay, Your Honor, I'm sorry. I don't, but I know that there will be several matters that I will be requesting exams with. So I would defer to the court, whatever dates where I'll be able to set multiple exams.
Right now, it's pretty much the same.
Okay, the 5th is
You want to
fine.
do June 5th?
The 5th, yes.
All right, let's do it at noon. 12 noon?
Your Honor, could we do early? Like I said, it's gonna probably.
I can't get any earlier.
So they're all gonna probably.
They're gonna be afternoon dates.
Okay,
Yeah.
12 noon is fine. Your Honor.
Okay.
Thank
All
you.
right. Anything as to bond, gentlemen?
Yes, Your Honor, I would like to address bonds.
All right. So let's just make sure we're all on the same page. It looks like the bond is currently 15,000, 10%,
That is my understanding.
with no special conditions.
That's my
Okay.
understanding, Your Honor.
Go ahead.
Simply, Your Honor, Mr. Zeman, I would just indicate that, my discussion with Mr. Zeman. Mr. Zeman does, of course, stand presumed innocent. He indicated to me that he, in essence, has no access, to any funds because he, the only possessions that he had were taken into his property. He has no one here in Michigan to, access his, he's from New York, Your Honor, and he was here visiting. And he has nobody here to access his personal property, to sign off his property to. And so he has had no way to access any funds or any way to even try to post a bond, Your Honor. He has asked me to ask this court to consider a personal bond. He offered to stay here in Michigan until his exam date, which the court has set for next week. And he indicates that, simply put, Your Honor, that if he could access his funds, that he would ask maybe for maybe a 5,000, 10% or something like that. But he has no way to access any funds, and he's asked me to ask the court to consider a personal bond and that he would appear. Your Honor, my discussion with Mr. Zeman, while he does have several charges here, I think that he has a fairly reasonable explanation for how things get to the point of his actual encounter with the police, Your Honor. And I would point out that that this is a situation that occurred at the airport with the rental car where there was some suspicion. Police showed up, but Mr. Zeman is not charged with anything in relation to trying to do anything fraudulently with the car. There was an accident with the car. He's charged with malicious destruction, and I guess that would be really the only real point of contention is whether Mr. Zeman was intentionally wrecking the car or whether he accidentally maybe
Right.
So I would ask the court to just take that. I'm not here to try the case, but I'd ask the court to take that consideration in regards to.
Okay. On behalf of the people, Mr. Muhammad.
Judge, the people would object to change the bond. There's been no change circumstances since when this was set. Also, from what I'm looking at in regard to the docket, it does appear that there is a forgery charge related to this case. Also, 2 R&Os along with the malicious destruction of property. So based on that, I would object to changing the bond. I don't think there's been any difference in circumstances.
The other charge is a allegation of possession of an ID.
Right.
But again, that was not. There's no allegation that is related to this vehicle.
Understood.
In any way.
Understood.
That once them taken into custody, that he was.
Understood. Understood.
I would indicate, Your Honor, that there is a slight change in the sense that when the bond was set, it was probably said, or at least with some contemplation as to whether he would or would not be able to make it. And I think one thing that has changed is that we can see he clearly cannot make it, and he has provided an explanation that I think is very reasonable as to why he has no opportunity to do so.
Yeah. All right. My major concern, Mr. I'm looking at, he's a New York resident and he's got warrants out in New York, so he doesn't even take care of stuff in his home state. I'm asked to trust him to take care of stuff here. That's my concern. He's got outstanding warrants out of New Jersey and New York both.
From what I understand, those are in-state pickups only, Your Honor.
I'd release him on a GPS tether, but I don't know how he's going to get a tether if he doesn't have a residence here.
I would ask the court to consider. I think that if the court is correct, I mean as the court indicates, the tether unit will not place him on tether.
That's my understanding.
Without
permanent address.
Some assurances through him as to where he's going to be. I do believe that they can tether individuals to a particular hotel or to a particular, because they can say, hey, you're in this zone.
Right.
Leave the zone.
Right.
So since this has been set for exam, which occurs next week, I think we should just readdress bond at that time. Maybe that individual will have a residence at that point, and I think we should just leave everything how it is until the exam date and then re-come back.
Yeah, that's, with all due respect,
Sorry. I'm gonna change it, understanding, I don't think there's much of a chance GPS tether's gonna work with him. But if they can tether him, so I know where he's at,
that's fair.
I'll let him out on a personal.
That's fair.
But Mr. Zamet, understand, if you can't give them a permanent address locally, I don't think they're gonna put you on a tether, but I'll give you that option if you can work it out with the tether unit. You understand that?
I do understand, Your Honor. Your Honor, if I could just say one thing, and really quick. Again, I have no one in Michigan to release my wallet to, my phone, where I can have access.
Understood.
Mr. Salmon.
I'm sorry.
Mr. Salmon,
I-
the judge has agreed to give you a personal bond on
Thank you.
tether. It's the
I
best
know,
that
but
we can do.
I'm hoping that they can do that, but I just feel like because I'm from out of state, that may work against me, and that I'm gonna have to stay here and in the same
It
position.
is gonna work against you. I just told you it's working against you.
Mr.
All
Salmon,
right.
it may.
I'll do my
it may,
best.
At the end of the day, it's customary, it's the best that we can do.
Okay.
Understand?
Okay,
All right.
thank you.
You're welcome.
Well said, Your Honor, I'm gonna go.
Yeah. Mr. Zamet, I'm gonna put you on a $15,000 personal bond, subject to the GPS tether before you're released. Do you understand that?
And that's with 10%?
No, that's a 15,000 personal bond. So that
Oh, I'm
means
sorry.
if
Right.
you are released and you don't show up in court next Wednesday,
Okay.
or you commit some other crime while you're on bond, I will revoke that bond until you come up with 15,000 cash.
I understand that, sir, Your Honor.
All right, raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $15,000 if you screw this up?
I do, Your Honor.
Good luck.
Thank you.
Thank you, Your Honor. All the best to you and your staff.
Thank you, Corporal.
Judge, is Mr. Bickert still in there?
He just walked out.
Now to talk to Ms. Johnson.
Okay, good. Good morning, Carrie. Do you need to talk to Mr. Emery?
Good morning, Heather. No, I'm all right. I talked to him this
I'm
morning.
Michelle,
We're
but
ready to
that's
go.
okay.
Oh, I'm sorry. Hi, Michelle.
What are we doing? Are we setting it for exam?
Yes.
Okay. Judge, we're ready on the Josh Emery.
I'm sorry, last name is Emery?
Correct.
Counsel, your parents.
Good morning, Judge Oakley. Good morning to your staff. Neighborhood Defender Service, Carrie Martin, P84592. Appearing on behalf of Mr. Joshua Emery, who appears by Zoom with the court's permission. Mr. Emery, your full name for the court.
Joshua Michael Emery.
Good morning, Mr. Emery. Go ahead, counsel. What are we doing?
Good morning, sir.
Your Honor, we had referred Mr. Emery for competency and criminal responsibility evaluations. We've received a report back from the CFP finding Mr. Emery competent. We are prepared to stipulate to his competency and proceed on with this case by setting it for preliminary exam.
Okay. I'm looking at June 5, July 10, or July 17 for dates.
July 10th would probably, yeah, I'm out of town June 5th. So I'll take the July 10 date. That would be great.
How about 12 noon?
Great.
That's perfect.
Anything as to bond?
No, Your Honor. Mr. Emery is on a tether from Wayne County. Meanwhile, he resides in Kalamazoo County, and I don't believe we're seeking any changes at this time.
Bond will be continued. We'll see you guys in July.
Thank you, sir.
You're welcome.
Thank you, Judge.
Travel safely, counsel.
Yeah, Josh, you're free to go.
Okay, thank you.
And I'm expecting one more client zooming from MDOC at 10. It doesn't look like they're
All right.
here yet.
I'm sure Michelle and Heather will watch for him.
Thank you.
Ms. Johnson, Ms. Bickert, if you join the breakout rooms.
Yeah, it's a beautiful judge, that's, yeah, like. Correct. Washington, he orders a guy for confidence exam, and he picks a date for confidence exam right then.
Well, we can too, but if we don't have paperwork back.
Well, I know, but I mean, he's not doing it because he expects to adjourn 4 times.
Yeah.
They must be that caught up with Washington.
If they're in custody, we can do probably 60,000. If they're not in custody, it's at least 3 or 4 months before they're even scheduled.
Because.
Yeah, if he's. And they're doing it at the same place as us.
They send them all those lines, right?
No, it's, you can use Zoom. If you call them and say, I can't come in, they tell you that you have to find a Facebook page and you have the thing. It can be at the courthouse. And then they can.
Miss Lewis, is that you?
Yes, ma'am.
Okay, Mr. Martin, where'd you go? Carrie, do you need to talk to her?
Hi. Yes, if I could just briefly chat with Ms.
Absolutely.
Lewis.
Yep, give me a minute.
Good morning, just letting you know I was here, sorry.
Miss Johnson, we lost Mr. Bickert again. Do we know what we're doing? Are we setting it for an exam?
Yes, ma'am. I think he said he can set it for next Wednesday, the 5th, and then if we waive that date,
Let me
that'll be
bring
what
him
happens.
out. Let me bring him out.
Michelle, he's probably talking to the defendant.
Oh,
Yeah, he said he needed to speak to the defendant, and the defendant is here in person.
okay.
If
Is it what you're doing, Mr. Bickert? You're talking to the
yeah, if we could
defendant?
just have like 2 more
You're
minutes,
okay.
then I'll be
Just
ready to
mute.
roll.
Yeah,
Yep.
just mute. You're fine. Good morning, Miss Bates.
Good morning. How are you?
Good, how are you?
Good.
Which case are you here on?
I am here for Thomas Basher, and he should be coming on through the Washtenaw County Jail.
Okay. I haven't seen him yet.
Okay.
Heather, do we have Mohammed on here?
He'll be on in a few minutes.
Okay.
Yes. Yes.
Council, I am ready on Fuller.
Sorry. Should have heard. I'm full. Sorry about that. Good morning.
Go ahead, Council.
Your Honor, and board, on behalf of Mr. Fuller, I don't think he's been arraigned. I waive formal reading and standing mute.
Thank you. All
And
right,
then
so
as to
go
the, thanks, as to the pretrial, he's going to be, the prosecutor's moving to dismiss count 3. He's going to plead guilty as charged to cycle endorsement and a reduced charge of no operator's license on person.
all right, so we'll dismiss the drove while unlicensed or without cycle endorsement. Take a plea to fail to display, right?
I believe so.
And then operate no license, multiple license. We're going to dismiss that one with drove without motorcycle endorsement. I guess it doesn't matter really.
No, I think that sounds right.
And then the registration of plate dismissed.
Correct.
Okay. All right, sir, did you discuss your rights and options with counsel?
Yes.
You understand all those?
Yes.
All right, and do you understand the possible penalty for the added charges today?
Yes.
Understanding all of that, are you pleading guilty to those charges freely and voluntarily today?
Yes.
All right, counsel, I got an incident date of October 11, 2020, if you'd like to voir dire.
Date, time, and location, did you fail to display a valid license?
Yes.
At that same date, time, and location, did you fail to have a cycle endorsement?
Yes.
For the vehicle that you drive at the time?
Yes.
Okay.
You satisfied, Mr. Correa?
I am.
So am I. I'll dismiss the original 3 charges. What should I know about Mr. Fuller before I sentence?
So we've cleared up Plymouth. He's currently clearing up Ypsilanti.
Good.
We're back here, I believe, in front of Judge Green in a week or 2 to clean up 3 old files. After that, we have Taylor, and I don't know that Detroit is doing anything to actually suspend his license. The whole point of this is trying to get him his license back. His fiance is in the back row here.
So it sounds like he's not there, but there's a light at the end of the tunnel.
We're getting there.
Yeah.
We're getting there.
Yeah. Time frame, what are you thinking?
Best
case scenario.
Money's always an issue.
We'll work with you on that. We'll take payments.
90 days, 120 days.
Okay.
Depending on what he has.
Okay. All right. Mr. Fuller, are you working?
Yes.
Where do you work?
U of M.
What do you do?
Custodian.
Okay. How long you been with U of M?
Excuse me?
How long you been with the university?
10 years.
Good. Okay. Is there anything else you want me to know before I sentence?
I'm doing the best I can right now. I just got diagnosed with either gout arthritis or rheumatoid arthritis on the 31st.
Good luck.
I go to the doctor to get the actual diagnosis of what I have and whatever they're gonna do with me from that. I've been off for about 5 weeks now. They took me off for 6 weeks. And that's where I'm at right now. But I'm working towards getting all this cleared up. So
Okay. All right. And it looks like you already owe us a lot of money on some other stuff.
He does. hoping,
Yeah, we got a pretrial coming up next week too.
correct.
You're on that one.
See what I can do to save
Yeah.
some money on those files.
All right. All right, so it looks like we've got 2 files out of 2016 Romulus tickets, improper lane use and no proof insurance. That's over $1,000 just on those, and then we've got some clearance fees. Are you in a position to get on some kind of payment plan? Can you commit to some kind of monthly payment, for example?
Yes,
Can you do that today, make a commitment?
yes.
Okay, all right. All right, so anything else on these 2 files before I sign? Mr. Fuller, on each one of today's files, I'm going to assess fines and costs totaling $550. So that's a total of $1,100. I'm going to send you down to collections. Add this into your collections plan. And also, if you can find the time for it, it's one of those deals, you got more time, you got more money. If you can find the time, we've got a program, you can get the details from Mr. Taylor downstairs, where you can do some charity work and we'll give you credit and knock some of this money off. So you can either do it all time or make your payments, some money's coming off, do some hours, bring us some documentation that you're doing some charity work, and then some more money's coming off, so we can close it out earlier than just all cash.
Cool.
To make it sense, I think I could have more clearly explained that, but did that make sense? Okay, so that's an option. Either way, you got to deal with it, go downstairs. Either add it into the current payment plan, so you just got a bigger total, or do that and then talk to Mr. Taylor and start working out some hours.
Thank you.
Got it?
Yep.
Good luck with those other courts.
Have a good day.
Counsel, good to see you.
See you later.
Mr. Martin, are we ready on your case?
We are, Michelle.
And Mr. Martin, which file is that?
That is Patricia Lewis.
Lewis?
This is going to be a waiver.
And I'll take that as an appearance. Go ahead and tell me what we're doing.
Yes, good morning, Judge Oakley. Terry Martin on behalf of Ms. Lewis. Ms. Lewis wishes to waive her preliminary exam today.
All right, Ms. Lewis, have you discussed your rights and options with counsel?
Yes, Your Honor.
You understand those rights and the options they give you?
Yes, Your Honor.
You understand the purpose for the exam?
Yes, Your Honor.
And you understand that if you waive the exam, that means you're done with the district court and we're going to send you for a court date at the circuit court level, which would be in 2 weeks. You understand all that?
Yes, Your Honor. Yes, Your Honor.
All right. Understanding all of that, are you waiving freely and voluntarily today?
Yes, Your Honor.
And Mr. Martin, are you satisfied with the waiver?
I am, Judge. The one thing that you said about being arraigned in 2 weeks, could that be a 1 week? Whatever. Thank you.
Yep, I got that. All right, so arraignment on information date would be next week, the 5th, 9 a.m. Mr. Martin, anything as to bond?
No, Your Honor, we would keep the bond the same.
I will continue bond then.
Actually, Your Honor, no, never mind. Yes, there was previously a nominal cash bond that was posted. That was mostly for purposes of accruing time credit. I don't think it makes sense to reimpose an additional one.
Money on this file. Yeah, a quick review. I'm not seeing any money on this file. Maybe she had another file with us. All right, so AOI date is next week, the 5th, 9 a.m. Is it? Okay, yeah, Heather says there is $100 posted on this file. It just doesn't show me anywhere, or at least I haven't figured out where to find it.
Yes, I think there's nothing more to be done on that front. But yes, thank you, Judge.
Miss Lewis, I wish you luck downtown.
Thank you, Your Honor. Have a blessed day.
You too.
I'll see you later, Judge Oakley. Appreciate it.
You're welcome. What time was she scheduled? I can't even find her on the list.
Mohammed, do you need to talk to Ms. Khan?
I'm having trouble finding her on the docket.
Yeah.
Thank you.
We'll just let Mohammed know.
Ms. Khan, do you need to speak to Mohammed?
No, I believe we're all set.
What are we doing on your case?
For the CCW from Mr. Sudeth, we're accepting a plea. I'd sent in that plea form.
Okay. And we have him on. Do you need to talk to your client?
No, I don't.
Okay.
And then on his other case, we're doing a waiver.
Okay. Judge, you got that?
Counsel, your appearance on Sudeth? Appearances on Sudeth, please.
Hi, how are
I'm
you
sorry.
doing?
Oh, I'm sorry, Judge. Are you calling the CCW or the DV case?
I'm calling them both, so.
Okay. Good morning, Your Honor. Patricia Mandernack for the people, appearing in case ending in 0346.
Good morning, Your Honor, and court staff, Neighborhood Defender Service by Sarah Khan, P86948, on behalf of Mr. Sudeth, who appears via Zoom. Mr. Sudeth, would you please unmute and state your name for the record?
Jimmy Sudeth.
And Mr. Mohammed, are you on the CCW?
Yes, Judge.
Thank you. All right, counsel, what are we doing on this one?
Your Honor, for the DV case, we're doing a waiver for the examination.
All right. Mr. Sudeth, do you understand your rights and options after discussing those with Ms. Khan?
Yes, Your Honor.
And you understand the purpose for a preliminary exam?
Yes, Your Honor.
You understand if you waive the exam, that means your next court date will be at the circuit court level, not at the district court where I sit.
Yes, Your Honor.
Understanding all of that, is it your desire to waive the exam today?
Yes, it is.
Ladies, are you both satisfied with the waiver?
Yes, Your Honor.
Yes, Your Honor.
So am I. Arraignment on information date, June 12, 9 a.m. Anything as to bond on this file?
Nothing from the people, Your Honor.
Your Honor, I did
will
have
con-
one matter related to the DV case. I know the last time that we were in court, I had indicated that Mr. Sudeth, because of the no contact order, has not been able to see his son. Now it's been 2 months. At the last court date, you had indicated whether or not we could find a solution via a third party. Mr. Sudeth believes that the complaining witness's mother would be willing to do that. And so we just wanted to put that on the record.
Judge, I would have no objection to a third party exchange.
Okay. Ladies, are you okay with if I just make the bond alteration to third party exchange, or you want me to pick a specific third party?
No contact except via third parties regarding the minor children.
That works for the defense.
All right, that's what I'm making a note in the file. No contact except child exchange through third party.
Thank you, Your Honor.
Anything else?
Thank you, Judge. No, Your Honor.
All right. Ms. Khan, are we ready to move on to the CCW file?
Yes, Your Honor.
What are we doing on that one?
We're accepting a plea today.
And Judge, the plea in that case was sent to the defense attorney and the and then Madam Clerk. I believe I CC'd her in that.
Yeah,
email.
I'm looking at it now. Having trouble accepting new forms. I got to get my eyes used to it. So he's going to plead to misdemeanor 750.232A, 90-day max, sentence recommendation, 12 months probation, forfeit the weapon, cannot possess a gun while on probation, and 40 hours community service. Additional terms and conditions as set by the court. That cover the agreement?
That is correct, Judge.
And
Ms.
I've
Khan?
gone over that with Mr. Suddeth, and he would like to proceed with accepting that today.
Mr. Suddeth, is that what you want to do today? Take that deal?
Yes, Your Honor.
Okay. And you understand your rights and options as they apply to this case, correct?
Yes, Your Honor.
All right. Counsel, would you like to voir dire? Give me the facts I need. I've got an April 9 offense date.
Judge, are you speaking to me or the defense attorney?
Ms. Khan.
Oh, okay. Sorry, could you give me that offense date again?
Sure. Offense date, April 9.
All right. Mr. Suddeth, on April 9th, did you have an interaction with police officers?
Yes.
And they pulled you over? And they pulled you over?
Yes, my apologies.
Nope, that's okay. And when they pulled you over, did you have a pistol on you?
Yes.
Okay. And at that time, did you have a valid CPL?
No.
Thank you. Defense is satisfied.
Mr. Muhammad, you satisfied with the factual basis?
Yes, Judge. Assuming that that was in the county of Wayne and the city associated.
This was in the city of Romulus, sir?
Yes, Your Honor.
Satisfied, Judge.
Thank you. And Ms. Khan, any objections to an immediate sentencing?
No, Your Honor.
All right. What should I consider before I do so?
Your Honor, Mr. Suddeth has done his best to comply with the law. He completed a CPL class. He had taken in the certificate to the police department and registered. He was ultimately denied a CPL. And, you know, hadn't known that information at the time. He's working, he cares for his children. And, you know, I believe that once these cases are resolved, he'll be back to being a great father and working.
Okay. Mr. Suddeth, where do you work?
I work for Roush. We just
How long you been with Roush? I've
been there for 3 weeks now. With everything that's going on, I was doing the tow truck drivers, but we tow for the police in Detroit for Troy's Towing, and you know my background had came back with the case that I'm going through now, not the CPL case,
right?
The one before, and I got laid off until further notice of that case being taken care of. However that goes.
How long were you with the tow company?
For 2 years.
Okay. All right. And you've been at Roush 3 weeks. Is that a full-time job too?
Yes, it is.
Okay. All right. Anything else you want me to consider before I sentence you?
No, sir.
Counsel, anything else?
No, Judge.
All right. All right, Mr. Suddeth, I'm going to put you on a non-reporting 12-month probation. The first condition is the obvious one, no new criminal charges. Ordering 40 hours community service. In keeping with your agreement with the prosecutor's office, forfeit the weapon, not to possess any weapons during that 12-month period. Court costs and fines total $500. You can set up a payment plan here with the court. I'd like you to do that within 5 days. So yes, get in here within 5 days, commit to some kind of regular payments, weekly, bi-weekly, monthly, whatever works for you. When you come in to set up your payment plan, I'm sorry?
I apologize, sir. You can continue.
I said, when you come in to set up your payment plan, you can also get some information about community service. We've got some organizations in our area that are pre-approved. You don't have to use them, but it's an easy way to get started on those hours. Understood?
Yes.
You have a question?
No, Your Honor.
Counsel, anything else on this file?
No, Your Honor.
All right. Good luck, Mr. Suddeth. Good luck downtown.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome, counsel. What's that, Joe?
We'll wait on Mr. Baker.
Thank you.
Ms. Henderson, do you need to talk to your client?
Good morning. No, I've already spoken to her. Thank you.
What are we doing on your case?
It'll be a plea. I sent over the plea form.
Okay, Judge, it's on Amanda Sims.
I'm sorry, say it again. Sims. Counsel, what's your appearance, please?
Good morning. I'm sorry I didn't hear you.
Your appearance, please.
Sydney Henderson with NDS P84839 appearing on behalf of Ms. Sims. Ms. Sims, can you please state your full name for the record?
Amanda Race. Actually, it's Reese, but Sims is my maiden name.
Thank you. Counsel, what are we doing on this file?
Your Honor, at this time, people have extended an offer to reduce the charge to use of a controlled substance, with the sentence agreement being 12 months probation, controlled substance assessment, testing and treatment as determined by the assessment, no alcohol or non-prescribed drugs during probation, no new criminal contacts, and any other terms and conditions set by the court. At this time, Ms. Sims does wish to proceed with entering a plea and accepting that offer.
Thank you. Ms. Sims, you understand your rights and options after discussing those with counsel?
Yes, I do.
You understand the possible penalty for the added charge?
Yes, I do.
Understanding all of that, are you pleading guilty freely and voluntarily today?
Yes, I am.
Counsel, incident date of April 30, 2024. If you'd like to voir dire to give me the facts I need for a plea.
Thank you. Ms. Sims, on April 30th, were you in the city of Van Buren Township at Walmart?
Yes, I was.
Is that in the county of Wayne?
It's in the county of Belleville.
I'll take judicial notices, Wayne County, counsel.
Thank you.
Okay.
Did you have police contact on that day?
Yes, I did.
And when police made contact with you, were you in possession of a controlled substance?
Yes, I was.
And what was that controlled substance?
Crack cocaine.
Defense is satisfied, Your Honor.
So am I. I'll dismiss the original count one. I'm going to refer Ms. Sims for a pre-sentence investigation, and the probation department will pick a sentencing date. Cedar Cliff is a good address, Ms. Sims?
No, sir. I just moved out to Inkster. I just gave my new address to the clerk.
Okay, it's in the computer then.
Okay.
Okay. Counsel, anything else?
No, Your Honor.
I'll continue bond. Ladies, enjoy your day.
Thank you.
Thank you.
Mr. Bickert, are we ready on Robinson? Yeah. Your appearance, counsel.
May it please court, Your Honor, Tyrone Baker, appearing on behalf of Mr. Jelani Robinson, who's present here tonight.
And what are we doing today?
Your Honor, we are respectfully requesting to examine this matter.
All right.
Ask the court to consider, I did speak with Madam Prosecutor in this case, we both, I believe, are available on June 5th.
Yeah, let's do it at noon. I already got your one at noon, so let's do your second one.
Sounds good. I would indicate, Your Honor, I will be meeting with Ms. Robinson in regard to, yes.
Yeah, it's confusing when they got the same name.
Yeah, I wanted to make sure I wasn't messing up. Regarding this matter, I do think that there is at least some possibility that this could end up in a waiver.
Okay. Yeah, that's no problem. All right. Yeah. Anything else to bond?
No, Your Honor, I don't believe.
All right. I'll continue bond. Next week, Wednesday, 12 noon. We'll get you a paper notice, Mr. Robinson.
Thank you, Your Honor.
Thank you, Judge.
Counsel, you got one?
Yep. Mr. Hill. Sorry, Hillsaback.
Come on up. Come on up, Mr. Hillsaback. Am I saying that right? Hillsaback?
Yes, sir.
Counsel, your appearance?
Morning, Your Honor. Spencer Clayton appearing on behalf of Mr. Hillsaback, who approaches, stands to my right, P number 77302. Sir, can you state your name for the record? Shannon Lee Hillsaback.
Go ahead, counsel. What are we doing?
Today is date and time set for pretrial in this matter. I did have the opportunity to speak with the people. They have offered to add a count 2 of careless driving and civil infraction. My client does wish to plead responsible to that today.
All right, Mr. Hillsaback, have you discussed your rights and options with counsel?
Yes, sir.
You understand all those?
Yes, sir.
Understanding those, are you pleading responsible freely and voluntarily to the added charge today?
Yes, sir.
I'm satisfied if you are.
Satisfied, Judge.
I'll dismiss the misdemeanor. What should I know about Mr. Hilsabeck before I decide what fines and costs are gonna be?
Your Honor, I don't think he's been in trouble for, I think he has one felony 20 years ago. He was working when this happened. He acknowledged to police that he should have stopped. It was a stupid decision.
Who do you work for, sir?
Do like tree service.
Okay. What's the name of the company? What's the name of the company?
I'm not very sure the company. I just do it like at the side.
You just like day
side
labor?
job.
He was doing a side job.
Yeah,
at this point.
okay, all right. License is clear, everything else?
Yes,
Yes.
sir.
Okay, all right, anything else?
No.
It's
All right.
not one of those cases, Judge, where I know sometimes the court's always concerned that this is like a drinking and driving.
Right, right,
This
right.
is in the middle of the day. It's not.
Yeah, I don't see any indication, yeah, just panic.
Yep.
Yeah, you're old enough to know better, but I get it.
Yes, sir.
All right, fines and costs, $220. Can you pay that today, or do you need a payment plan?
I need
Go on downstairs and make that happen.
All right, thanks,
Thank you,
Judge.
sir.
Have a good day, fellas.
Thank you.
Yeah, well, I was careless with accident, but I don't special. Well, I wrote it up that way. Yeah. Try to find five. You might not have it. Heather, civil infraction for Midwest Towing. We probably don't have a
If it's
file.
just a pre-hearing, we'll have to get it.
Take that downstairs, okay? You can just go downstairs, they just.
I got this one and then.
Yeah, they just dealt on the five calls. At 12:30, we're supposed to zoom in.
They already did, so that was,
Oh, that's received.
the Midwest can go upstairs and they have your stuff, just, pay for 500.
All set?
Yeah, you're all set.
You go downstairs, you get. Thank you.
Yeah, thank you.
If I give you a name, can you tell me what your guys' address is? Well, at least I got a simple question. Case on that.
Do you have this one?
Yeah, I don't know if this name is the defendant. 16-1015.
Nicholas Bell. This is camp. At least that's what we have. Oh, he's got 1, 2, 3, 4, 5. He's got 7 warrants. Starting with our 2 OWIs. So, yeah, he's that close to it. I'm thinking probably requesting because I'm June 18th with just 3 minutes. That must be wrong. What's the name, Joe?
OGR
Is
Transport.
another one?
I bet it's silver.
Do you have a piece of paper?
Yeah.
Oh, wait. Adjourn 2 weeks.
First time since I got out of
Is earlier better than later?
I'm not
Like
getting
9:15 or is that
3 hours.
Nah, no.
People watch this kid. 2 through 7 is this time.
Yeah. Yeah.
Oh,
Yeah.
all right, thank you. And, you know, it's a 10 o'clock ceremony. So that means, you know, it'll be 12, 1 o'clock probably. It's like right in the middle of the day. Don't know, haven't been to one since when. No, I take it back. I went to Cheyenne's, I'm sure. I just don't know. Well, I'm sure it's at high school. I just don't know if they do it out on the football field or if they do it in the auditorium. I have no idea. It might say on the invitation. What's that? Guys, hey, what are you doing? At the high school. Graduation one.
What do you plan on doing?
What?
I mean, she's not on Zoom, nobody's here, it's after 9:30. So we can just cancel it and. All right.
I think we read all.
Oh, I was just like, I paused because I have this sort of connection issue. So I am the second sit. Did you have anybody else? I got your own, we set our pre-trial, that was 10:15, it's 10:30. Yeah, I just want he has heard.
If it does. BY?
Right, thank you, thank you. We don't know, we're not sure who the prosecutor is on. It's not Mohammed, so no.
So defense and the defendant are here, but there's no prosecutor.
Correct. And he's not. Oh, I was gonna say, do you want me to check? Okay, this is the. I'll see if it's. Maybe I can, maybe I can't. Thank you so much. Hey, Mr. Roberts.
Well, I guess we'll give her a minute to find out who they're before we go to bed. Hey, can we have the guys match their docket to let me know who's here and who's not?
Good morning. Who do we have from Washington County?
Procopio Vitale.
Perfect, thank you. Ms. Henderson, do you need to speak with them?
Yes, please.
June 5th.
Mr. Johnson, tell me you need to join the breakout room. You got it.
What's the guy's first name?
Sean Ted. Last name Gregory.
Oh, there it is. Got
So
it.
they did tell me you have it.
Yeah.
On in a breakout is Johnson. Yeah, they're in Washington.
Janice?
I'm sorry.
Janice first name?
Procopio? No.
The only Johnson I've got is Janice. John.
No, we have Procopio Vitale.
Oh, Vitale is the last name. Vitale.
That file I've got. They ready?
No, they're in breakout. I was just getting you the
Michelle, did they say if they have Basher as well?
The lady was standing behind the glass, so I didn't get to ask her. I'm gonna have him bring her in when they come back.
Didn't we just have a conversation last week or so about
They're all over the place. You should see how many are coming across that you mentioned that. There's so many.
what's going on, Ken?
Not too much, Judge. Can I get, Big Ed's towing, please?
Which one?
Big Ed's towing.
Oh, I know.
Oh, okay. I didn't know.
I gotta pull a file. Thank you.
Logan, this client, during 3 weeks.
Adjourn. Dots are here? Awesome.
That's about it.
Thank you. Thank you, thank you.
Everything's switched.
So dots are present.
It's on the 18th, which is a Tuesday, because on Wednesday, of course, closed. So we do.
What Wednesday are we closed? I'm sorry? Okay.
10 o'clock, man.
Good. They were at my house last night. Doing well. We determined this weekend that my grandson, who is a year behind his cousin, outweighs his cousin by 3 pounds. Yeah.
Good morning. Can you give me your name?
Stephen Schillinger.
Gotcha. Okay, Mr. Schillinger, we're just waiting for your attorney.
Okay, thank you.
You're welcome.
Why did we let Schillinger Zoom? Do you remember?
He's on right now.
No, but why did we do that by Zoom? Do you know?
Yeah.
Ken came and got the file.
Good morning, counsel.
Good morning. How are you?
I'm good. How about you?
I'm well, thank you.
Do you need to talk to your client?
I believe we're just trying to set a preliminary exam, so
Okay.
maybe I can speak with him afterwards. Thank you.
That's fine. Judge on Schillinger.
Thank you, counsel. I'm ready for your appearance.
Good morning, Neighborhood Defender Service by Kate DeMott Grady, P83667, on behalf of Stephen Schillinger, who joins us from MDOC via Zoom. Mr. Schillinger, please state your name.
Stephen Schillinger.
Thank you. Counsel, how about next week, the 5th? Too soon? Too soon? How about July 10th?
Is so it's either, yeah, I guess for the writ, probably next week is too soon. July 10th works for me. There's nothing available sooner.
Unfortunately, no.
Okay.
12
Understood.
noon?
12 noon works.
All right. Anything as to bond?
Nothing as to bond. Well, actually, no, nothing as to bond at this point, but if I may have a breakout room with Mr. Schillinger.
Okay. Michelle, can you do a breakout room?
Of course I can.
Thank you.
Okay, Ms. Henderson, are we ready on your case?
We are ready.
What are we setting it for?
We are going to waive the exam.
Okay.
I guess it's a weird thing where.
Counsel, your appearance on Vitale.
Good
Right
morning,
here.
Cindy Henderson with NDS P84839, appearing on behalf of Mr. Vitale. Could you please state your full name for the record, sir?
Procopio Vitale.
Good morning, sir.
Good morning, Your
Go ahead,
Honor.
counsel.
Your Honor, at this time, I have explained the purpose of the preliminary exam and what would occur and the rights that he has associated with that preliminary exam. It is his wish to waive that exam.
All right, and this is on both files?
I am not representing him on the other file. I'm sure that once the court sends it over, they may have us do that. But I don't have
Okay.
any discovery or anything on that case, so I can't waive that exam without any of that information.
All right, which file are you on then?
I am on the one, give me 1 second, I'll tell you the case number for it.
Case number, incident date, either one will help.
Incident date is 4/19.
Okay, I've got a November 10/22, same charge.
Yep, so it is the same charge, but I don't represent him and I don't have any of the case information for that.
Understood.
November date.
Understood. All right, so counsel, I'm looking at July 10th. How's that work?
Is that going to be for the exam in the new case?
I'm sorry?
Is that going to be for the exam in the November case, the new case that I don't yet represent him on?
It's going to be the exam date period. So hopefully they appoint you on the other one so you can take care of them both.
So for this exam, he wanted to waive that exam. Do we have to wait until the
Oh, he
exam?
wants to waive.
He
I'm
wants to
sorry.
waive his exam, yes.
Okay. All right, so what do you want to do on the other one? Okay.
Is it possible that we
Counsel,
can-
would you waive
during the
formal
PCC?
reading? On the November 2022, would you waive formal reading?
Yes.
I'll enter not guilty plea, PCC win. Let's do it the same day I do the exam.
We're not doing an exam.
We're waiving.
We're waiting. So just do 2 weeks out so that I can get confirmation from MDOC.
All right, so we'll set a probable cause conference for the 12th
Okay,
at 9 a.m.
okay.
All right, and Mr. Vitale, on that one, I'm just gonna put you on a personal bond.
All right, thank you.
I'll hold you up on this file.
Thank you, sir.
All right, and the 12th is with TBG, right? All right, so we're gonna set you up for a Zoom hearing at 9 a.m. on the 12th. In the meantime, I'm gonna put you on a personal bond on that file. So
right,
first
thank you.
condition is the obvious one, you stay out of trouble. Second condition, show up in court or on Zoom on the 12th at 9 a.m. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to court in amount of $5,000 if you mess up on bond?
I do.
Any questions about that file, sir?
No, sir.
Okay, on today's file, you can put your hand up. Did you discuss your rights and options with counsel?
Yes, Your Honor.
And did you discuss the purpose for a preliminary exam with Ms. Henderson?
Yes, Your Honor.
You understand that if you waive the exam, that means you're done at the district court level on this file. We're going to send you downtown at the circuit court level with your next court date, which will be next Wednesday. Do you
Yes,
understand
Your
all
Honor.
that?
Yes.
All right. Understanding everything we've talked about, are you waiving your exam on this case freely and voluntarily today?
Yes, Your Honor.
Ms. Henderson, are you satisfied?
Yes, Your Honor.
All right, as I said, June 5, 9 a.m. Anything as to bond?
No, Your Honor.
Actually, it looks like he doesn't have a bond on this file.
He's
Somehow
gonna
we
be
got to this
in
point with no
the
arraignment.
Oh, he hasn't been arraigned on
again?
this case either.
Say again.
He's gonna be in Washington County until November, so a cash bond is fine, Your Honor.
All right. All right, on this one, I'm gonna put a bond on 10,000, 10%.
Thank you.
All right. Good luck downtown, Mr. Vitale.
Thank you, sir.
Mr. Vitale, can
welcome.
you get the deputy or whoever's work?
Yes.
Sir, thank you.
Yep, hang on 1 second.
Sure. Yeah, I'll dismiss. Yeah.
We just want to know if they have another defendant.
Do you have another defendant?
What? Wait, what? Heather, don't they
We're
have
done
another
with
one?
Mr. Vitale.
Thank you, Your Honor.
You're the only one for.
They said I was the only one.
Okay.
Thank you, ma'am.
Okay.
Did you have
Thank
another
you.
one?
Heather, don't we have Mr. Vasher? Thomas Vasher.
He is currently with his parole agent conducting his PSI. I'm not sure if you want to reschedule him. I can go see if he's done.
Can you check because
Yeah,
we
why
have
don't
his
you do
attorney
that?
on?
Okay.
Thanks.
Johnson, can you see if Basher's almost done with his Okay, and tell him that he has court, a Zoom red court.
All right. Yeah, just put that on the other file that we set the PCC for.
Good morning. Are you Mr. Vasher?
Yes, ma'am.
Okay, Miss Bates, do you need to talk to Mr. Vasher?
No, we're all set. I went to visit him in person.
Okay, what are we doing?
We are going to schedule his preliminary exam.
Okay, 1 minute. Let's get, we need to get the judge. Did you get that, Heather?
Yep, I did. I got it on here. Thank
Okay.
you.
So they're just gonna let me stay here or?
Yeah, just stay there for 1 second.
No, I was saying stay here in Washington County.
Oh, I don't talk. Your attorney will talk to the judge. Hold on.
All right.
All right, I'm ready on Jamel Lee.
Ready, Your Honor.
Appearance?
Your Honor, for the record,
Good morning, Your Honor. Patricia Manganick for the people, P840888.
Your Honor, for the record, Jeff Bowden is appearing on behalf of and with Mr. Lee in place of his attorney of record, Mr. Hadley, for these proceedings alone. Mr. Lee, would you tell the judge your name for the record, please?
Jamel Lee.
Thank you, sir. Sir, do you mind that I sit in for your attorney of record for these proceedings alone?
Sorry, sorry.
All right. Thank you, Your Honor. Your Honor, today's the date and time set for a final pretrial. I believe, if I'm correct, we may be absent a complainant in this matter.
That is correct, Judge. Both complaining witnesses have failed to appear in this matter. I cannot proceed without them.
We would make a motion for dismissal without prejudice, Your Honor. I have
Granted.
made an explanation to Mr. Lee exactly what that term means.
All right. Your motion is granted.
Thank you, Your Honor.
Thank you,
Thank
Judge.
you.
Thank you, ma'am.
Thank you.
Are we ready on Thomas Basher?
Yes, Your Honor.
Counsel, your appearance.
Good morning, Your Honor. Melanie Bates, P 76080, appearing on behalf of Thomas Basher, who is present via the Washtenaw County Jail by Zoom. Mr. Basher, can you state your name?
Thomas Vasher.
Thank you, Mr. Basher.
Yes, Your Honor.
Counsel, what are we doing today?
Your Honor, we'd like to schedule his preliminary exam.
July 10, July 17.
Was we gonna talk to him about being the treatment?
That when I get to your bond portion, we have to schedule first.
Okay.
I'm sorry, Judge, did you say July 10?
July 10 and July 17 are both options, both early afternoon time slots.
Okay, July 10th in the afternoon will work.
How about 1 o'clock?
1 o'clock works.
All right. Anything as to bond?
Yes, Your Honor. In regard to bond, it's my understanding that Mr. Basher does have a couple of pending cases out of the Washtenaw County Jail. I did pull his register of actions and I spoke with him, and there were plea negotiations. He is scheduled to be sentenced on June 13th. And a part of the sentence, he will be participating in a drug treatment court program. This case is definitely surrounding drugs. It's nothing in regard to violence or assault or anything of that nature. So I would like to see if the court would be willing to give him a personal bond with a tether so that he can be released into the treatment program. Because if he has any type of holds on him, he won't be able to go into that treatment program.
Sure.
Thank you. Thank you, John.
All right, Mr. Vasher, before you went in custody, were you working?
Yes, Your Honor.
Where did you work? Who'd you work for?
I was just for my son. He owns a pawn shop, and I was working, on and off for him,
How long has it been since you had a regular job with a regular schedule and paycheck?
Since 2019.
19, where'd you work then?
Value World.
I'm sorry?
Value World thrift store.
Okay. All right. I'll put you on a personal bond. Counsel, I'm not going to mess with the tether because it gets complicated with 2 different counties involved. So what I'm going to do, put him on a personal bond, order no mood altering substances without a doctor's prescription. Sir, so your first condition on bond is stay out of trouble. Second condition is cooperate with your court date. So be here on July 10th at 1 p.m. And thirdly, do not put anything in your body that's a mood altering substance unless you got a doctor's prescription. You got all those?
Yes, Your Honor.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $10,000 if you mess that up?
Yes, Your Honor, we're good.
All right, good luck with your sentencing.
All right, thank you. Have a blessed day.
Thank you very much, Your Honor. Have a great day.
You too.
Thank you, Melanie. Have a blessed day.
Michelle, did we lose?
Yeah, I don't know where they went. There was nobody in there. I don't know how it logged off so fast.
He's still in room 212, but she's not, unless she lost custody or custody.
Oh, Mr. Schillinger? Yeah, he can log off, I'm sure.
Right, he's still in there, so I'm wondering if she just lost service.
She probably just left because we already did it.
Okay.
Huh?
Oh, we sure did.
Yeah, they just went and talked after.
Okay, we'll pull them out.
I've tried a couple times. I just figured maybe they logged off, but they didn't.
Mr. Bird, okay. Judge, Mr. Bird, when you're done.
Okay, I'm ready on Bird.
Right, Your Honor. May it please court, Tyrone Baker from NDS, appearing on behalf of Mr. Torres Bird, is present to my right, Your Honor. Your Honor, in this matter, we are respectfully requesting an exam.
June 5.
June 5 sounds good to me.
Let's do it at noon again.
Sounds good.
It's gonna be Bickert Day. Anything as to bond?
No, Your Honor.
Bond continued. All right, Mr. Bird, we're gonna give you a notice, paper notice. Give you a written copy.
All right, thank you.
Mr. Schillinger, you're all set. We'll log you off.
Sorry. Snuck up behind you. Yep. No show.
It is a notion.
Go ahead, appearances.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of, but unfortunately not with, Mr. Leonetti. Your Honor, I have no excuse for his absence.
All right, he'll go in the show cause pile.
Thank you, Your Honor.
Thank you, Judge.
Thank you, ma'am.
Thank you, Mr. Bowditch.
Your Honor, I think we're about done. There's nobody out there. I mean, as far as misdemeanors.
Yeah, I think we are done.
And I think that was my last one since Sudeth Wade.
Thank you.
All right. And you've got my cell phone number in case I forgot something.
Yeah. All right, thank you. Have a
Thank
good day.
you. You too.
I'm gonna wait a couple minutes, Judge, and I'll take off.
Thanks.
Heather, can I take Tyrone off of here?
Yeah, that's fine, because he's just got one more case left and that's in person.
So I got a couple files here. I'm not sure what's going on with those. Paris. Motion to dismiss. What's that?
That's our 11:30.
Oh. Okay. And then Mason, Wilbur Mason. Wilbur Mason. 9:45. Yeah, he's not on the docket.
He is on the docket. He's above Shanta, wearing coat Shanta.
Oh, okay. He didn't show up then. And then Swansner. $8:45.
Jonathan Jones. Yeah, Jonathan Jones, just showed up.
Well, that's not like Jonathan. What's going on?
Just waiting on the last one. It's gonna be a plea, but she's just walking over the plea with her client.
The Swanner here,
Which one?
8:45.
Wagner?
Jonathan Jones Swantner.
Is he outside? There's nobody outside.
Who's showing up? We'll double check. I wonder if that's German.
Kansas.
So for Squatter, the attorney just walked in right now. So I'm gonna go talk to him.
Thanks.
Oh, that's good. I don't know. He better show up. So. Also, this is the place.
Oh, Mackenzie's warrant files are over here.
I will double check.
Thank you. I'm going out to see our man on State Street tomorrow. I said I'm going out to see our man on State Street tomorrow. It's over, guy. Good. AT. Oh, it's just AP.
It's June 5th. Next at 10 a.m.
Zoom or in person?
In person.
Okay, thanks.
Exam? We're setting an exam?
No, this is the one that he was asking about.
Oh,
I had Jackson down today, but it's next week.
Okay. Are you ready on Swatner?
Yep.
Your appearance.
Good morning, Your Honor. Mohammed on behalf of Plea 86.
Good morning to you, your wonderful staff of my brother counsel, Jonathan Jones, appearing on behalf of Mr. Swanner. Yeah, we're asking to set this for an exam. I didn't know about date and time, but brother counsel told me if we came in, you would give us all that.
Yep. We can do it next Wednesday.
Let me take a look.
June 5, July 10, July 17th are my options right now.
Let me see. So next Wednesday is the 5th.
You're here at 10 a.m.
Yeah, let's just keep that in mind. So we'll do both of those, Jackson and.
I'm just saying.
Yeah, but we can't. We're not gonna be able to do the exam at 10 o'clock.
No, he's gonna be here.
Yeah, we can do it 11, whatever you want. The later the better for me. I do have a few stops.
Well, the problem is that's gonna be like 1:30 or 2 then.
I mean, that's fine. It's you tell me what you want.
What are we doing with 10 o'clock?
Our last pre-hearing was at 10:30.
No, he said he had something at 10 o'clock.
Yeah, he had something at 10 o'clock.
Just a pre-trial?
Yeah, PCC with us at 10 o'clock.
All right. Well, there's no reason we could do that at 2 o'clock.
Correct.
I anticipate it to go very fast. I mean, it sounds like it's just a one.
Okay, so the probable cause conference on Jackson is at 10 o'clock? Is that yours as well?
I have to review. I don't know.
It's just a retail file. I don't think it's.
Then I'd assume it's mine.
Yeah, my only concern is instead of making him come in at 10 for the PCC and 2 for the exam, let's have the PCC at 2 as well. And then that might mean you have to get a hold of somebody on your end.
No, we can just do the PCC at 2 o'clock. That works.
All right, that makes sense?
That's awesome.
Well, except for, I just gave Mr. Bicker 3 or 4 at noon. How many did we give you? Yeah, so you want to go 1:30?
Yeah.
1:30 next Wednesday?
That's fine. Perfect. Thank you, Judge.
So just for the record, Judge.
Yeah.
For my records, it's gonna be June 5th at noon, was it?
1:30.
Or 1:30.
1:30. So we're gonna move the PCC on Jackson to 1:30 as well.
Okay. Yeah, that works.
Mr. Jones will get.
You know, he's in costing Oakland. So I mean, I'll be here, but he's gonna be on Zoom, I believe.
If we already have it set up and he's in Oakland County, then can you just zoom in?
Yeah, why don't you just zoom at 10?
Sure.
So keep it at 10 on the PCC.
Yeah.
All right.
All right.
Mr. Swanner, you, a lot of stuff going on. You're not confused?
No.
All right, so your case is 2 o'clock next Wednesday.
Gotcha. Okay.
1:30, I'm sorry.
Thank you.
Yeah,
I started at 2. I had trouble moving off.
We're not confused at all.
Yeah.
Have
a good day, gentlemen.
Mr.
Swanner, hold on.
Mr. Swanner, hang on one second, I need you to be space.
How I do it. Just have a seat right there.
We're gonna get you a written notice, sir.
Okay.
Oh, so yours. Right, so I check the prices. Yeah. Thank you. Have a good day. Right.
Alright, thank you.
Okay. So when you were at Ann Arbor Stamp, that was under AppMax? Right.
Michelle, if you want to log off, you can. Just give me host.
All right.
Thank you very much.
In the courtroom, co-host or?
Right.
No.
Right.
Yes,
Okay,
other
cool.
courtroom. Or courtroom.
So I got a few minutes.
Yeah.
Peace out.
Did she just say peace out?
She did.
I love it when Michelle talks to me.
I can wait for a lot of times. Yeah. I mean, I know right now it shouldn't be, but you know that. Right now we can.
So we're gonna go with Kenneth first, and then what was your content? Contest Burger. So for hers, it's gonna be a 1 week adjournment.
So we mean that one record.
Sorry?
I don't think we do when Heather comes back.
Oh,
Has it been arranged?
Hers, yeah.
I do not believe so.
Then we will have one record.
That's what I figured, yes. It's set for a regular trial.
If you have any issues.
They promise.
We're gonna use Commando.
11:20.
Yeah.
Yeah.
Oh, yeah, it would still be in the morning. 2 weeks. I mean, it's always gonna be in the morning, just so you know that. I'm sorry. Yes, and next week is in person. Oh, okay, I actually remember that. Oh, what is it, 2:30? Yeah, I can go as late as 10:30. Okay, then we go next, yeah, we can do that. Oh, great. Nice. Yeah. I guess you're ready. 10:30 is great because you get the. That'd be perfect. Thank you. Thank you.
If you have, It's okay, I can do it. Okay.
was reviewing the case, I left my folder out. Yeah. The whole thing, that whole. I had they both said fraudulent, and I grabbed one, I thought it was, it goes to the last. They're on my folder from last. Today's literally a day.
Well, you've been doing great.
Thank you.
Where we at?
First, you are. That's important.
We got the file. Counsel, your appearance on Hearst.
Good morning, Your Honor. Megan McDonald on behalf of Mr. Hurst, who is a road change.
Counsel, would you waive formal reading?
Sorry, he has a leg injury, so I didn't want to.
Oh, that's all right. You're fine then, yeah.
Okay.
Yeah, you're okay.
Yes, Your Honor, for purpose of agreement, I will waive formal reading of the charges and will stand mute.
All right. And you need a probable cause conference?
No, this is not a felony matter, Your
Oh,
Honor. This is just a
misdemeanors.
state case misdemeanor, so we just need 1 week adjourned to
Okay.
deal with, try to work something out.
10:30 next week? All right. Pre-trial, June 5, 10:30.
Perfect.
All right. You're gonna talk me out of a personal bond?
No, I would hopefully keep you on that mindset, Your Honor.
All right.
My client's 42 years old. He has 0 criminal history. He's actually an ex-sheriff deputy. He's a pilot for Delta.
Okay.
This was
Well,
kind of-
that's a career change, eh?
Yeah, he did. He did a quick career change from law enforcement to being a commercial pilot. So he has.
All
no
right, that's
record.
gotta be an interesting path.
It was.
I'll
Yes,
defer to
yes,
him
sir.
on that one. I don't.
How the hell?
Well, I went to school for aviation. I graduated in 2003. I did take some law enforcement classes in college, but so when I graduated in 03, there was no, 9/11 had happened. There was no
Yep.
jobs
Yep.
whatsoever in flying. So
And you had to pay.
yeah,
your
had,
debts.
had to pay the bill. So I went back to school quickly, got my law enforcement license in Minnesota,
Okay.
and then got hired with the deputy.
Yeah, and then
sheriff's
when the job started to open up, you switched.
Yes, sir.
How long were you deputy?
About 8 months. So
Okay,
I-
not long at all.
No, I didn't.
Okay.
I didn't. It wasn't for me, sir.
That's an interesting resume. Okay, so I can trust him with a personal life?
Yes, he's retained counsel in this
All right.
as well.
So first condition of your bond is stay out of trouble. Second condition is show up either live or on Zoom next Wednesday for your court date. You make that happen?
Yes, sir.
Raise your right hand. Swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess that up.
I swear.
Questions?
No, sir.
Counsel, anything else?
Nothing further, Your Honor.
Good luck with your leg.
Thank you, sir. Appreciate it.
Oh, P80744.
80744?
Yes. Thank you. I can say that. Thank you so much. Great, thank you so much.
Joe, you ever buy anything from these guys? So I think what I want to do is I want to buy some small. So it's 1/10. So like that, although I feel like Buffalo. It's like a Buffalo look. What's the address?
that's okay. One quarter.
Mr. Baker, do you want me to call Mr. Mohammed? Thank you.
Oh, he was in here, that's why. Right.
Oh, and he left.
Humanistic value. Right, I don't want to get it. So then we have gravy. Mr. Bickert's on Gregory.
Yes, he is grabbing Mr. Mohammed right now.
You know what they're doing? Gentlemen, you ready on Gregory?
Yes.
Appearances?
Good morning, Your Honor. Mohammed on behalf of 486771.
May it please the court, Your Honor, Tyrone Baker appearing on behalf of Mr. Shantez Gregory, who's present to my left.
What are we doing?
Your Honor, Mr. Gregory had previously missed the exam date. He set the state. First, I would ask the court what we call his case.
I think we did that one. Check it. Yeah.
Fair enough. Your Honor, I have had several discussions with Mr. Gregory. It was my intention to set this case for an exam. As the court is well aware, one of my duties is to, I'm tasked with, if I have concerns about my client's competency to stand trial, that I'm to bring it to the court's attention. In this case, my concern is with the second part was the ability to assist in the defense. Because in my conversation with Mr. Gregory, I'm having a very difficult time with trying to get Mr. Gregory to just have basic conversation with me about like, hey, this is the next step in your process. This is what is going on. I don't know if that's because Mr. Gregory doesn't. I don't know why. I mean, so I don't. In giving examples, I don't mean to say. I'm not saying Mr. Gregory doesn't. I'm not saying he doesn't like me or he does like me. I'm not saying Mr. Gregory can't understand. I don't know why it's going that way, but it does cause me concern as to whether we could proceed without a competency referral, because I don't know why we're having these difficulties. And so I would any assistance from the court, I would welcome, because Ms. Gregory's case is not one that, given the delays with the forensic center and the extended amount of time that I would anticipate this case dragging out.
Yeah.
I don't want to refer.
It might not be in his best interest.
Exactly, Your Honor. And I think that this is a case that could have a much quicker resolution.
Right.
But again, as an officer of the court, I am tasked with that duty, and I do have that concern.
Sure.
I don't know where we're at. I don't know why that's happening.
All right.
And I believe I haven't had enough conversation with Ms. Gregory to know what his background is with regards to to anything.
Right. Yes, sir.
I've called him several times. Very difficult to talk to. I've been trying to schedule court dates for the last few weeks.
Okay, let me stop you right there. You don't get to schedule court dates. I schedule court dates. I schedule court dates.
Yeah.
Okay.
Reschedule.
People out there get to ask about court dates. I get to schedule court dates. So if he hasn't scheduled a court date for you, that's not on him. Just to be clear.
So if one was missed,
okay,
can I come down here and reschedule? Because that's what I did.
Okay. Yeah, but we gave you the date. You showed up and said, I missed my court date, and we gave you a date.
Right, that's what I was trying to do for the last few weeks.
Okay.
Make it a lot faster to get over with.
Okay. All right, so you understand what he's telling me?
Actually, I feel more than competent, to get it taken care of. That's why I'm here today. So
okay.
The only problem I'm having is very difficult to talk to him. Like I said, it's pretty simple,
Well, let me tell you this. And Mr. Bickert and I have worked together a long time. He's not the best communicator. Okay, but he knows what he's doing. Right. So at this point, if you don't want an attorney, then we can have that discussion. But if you want an attorney, I'm telling you, this guy has the knowledge to help you through this process. But he's got to do things. There's a, I hate to use the word again, but there's a process he follows to get you through this process. Okay. He's got to have some basic conversation with you. He's got to make sure you're understanding him. He's got to have you make some decisions along the way. Okay. but there's a way that he goes about that. Now, it sounds like, maybe I'm wrong, but it sounds like because of your frustration with getting a hold of him, you've kind of just kind of thrown up your hands like, I don't want to talk to you, buddy. All right, I'm not asking anything. All right. If there's just been that breakdown in communication, that's probably fixable. All right, because what he's telling me, and I agree with him, is if he can't have enough conversation with you to be comfortable that you're competent to move forward in the process, then he's going to have to ask me to send you for a competency exam, which is probably going to take 2 months minimum. Minimum. Okay. And while we're waiting for that to happen, nothing moves forward with your file. I'm looking at this charge. I know based on my experience, this charge 99% of the time is something that the defense and the prosecutor are going to work out some kind of a deal. Might even be, I'm not promising, might even be a misdemeanor plea, and you're done with this thing. I don't have to send you to a competency just because what I think is a failure of you two to have conversation. You follow me?
I understand everything.
Okay. All right. So my question to you is, do you want to have some more conversation with Mr. Bickert? See if you can do something on this file today. Do you want to say, I'm going forward without an attorney? And then we can have a totally different conversation.
I already know what the process is. It's not that complicated. I understand that too.
But that don't answer the question I just asked. The question I have for you is, do you want to talk to Mr. Bickert and move forward, or do you want to represent yourself?
I can represent myself really, because he's really not telling me anything. I've been trying to get to
understand. If you want to represent yourself, then I'm going to hold you to the same standards I would hold Mr. Bickert or any other attorney. That means you have to have a knowledge of court procedure. You have to have I'm going to hold you to the court rules that I hold attorneys to, the statutes that apply. You're going to be tasked with knowing those statutes and knowing how they impact you. Because I'm not going to law school with you. You follow me?
So in a case like this, what we usually
Sir, do you follow what I just told you? Do you understand what I just told you?
I understand everything you said.
Okay. So what I told you a minute ago is this type of charge is usually a negotiated plea, not always. All right. Depending on what the facts are, the prosecutor might say, I can't offer anything on this. It's either plead on the nose or go to the next step, which would be a preliminary exam.
What about take care of the day? That's a plea, right?
That's the only way it would be taken care of today, is if there's an offer from the prosecutor that you
because
like.
it's just a window. It wasn't broken on purpose, and there was a camera right there in the hallway. So it's pretty simple.
To answer your question, the only way it'd be taken care of today is with a plea. If he'll talk to you.
I'm trying to say something to you. Private. That's what I'm trying to get some.
You guys want to step out in the hallway?
Yeah, why don't we do that? Can I go outside? There's.
Yeah, you got other stuff? Go.
Yeah,
That's something that's being looked for.
All right, go ahead. Yeah.
Okay. So we're gonna. Okay. So let's. They're probably just.
Okay, yeah, step out.
One of Susie's friends just put up a school picture.
Yeah, it's gotta be her. Sit one with a 7 class.
Sit down.
No, it's either the one sitting down or it's this one up here. I can't tell.
If you look at, seriously, if you look at our high school graduation picture, her mother did her haircut. And I tell people, she looks like a 24-year-old librarian. Her high school graduation, I mean, the haircut sucks, she's got these great big glasses on. People find out the ones that she was saying, oh, did you meet? I said, we wouldn't even look at each other. She said, because she looked like a school librarian somewhere. And I was scared the hell out of her. What's that?
Ben's on the state nuns.
What do you want to do?
He's going to find. Business school.
I didn't pay attention.
Force his own way. Finds a way to get done.
Huh?
These are steps.
That's cool. Be the self-starter.
Yeah.
Ain't a lot of that anymore.
Good as fake.
Seriously, I'm gonna pay you to drive my vehicle around.
You're not making sense. I'm like, no, that's not a problem. That's not a problem. What we're trying to do is fix our house here. You don't have to worry about that. Yeah, so we just have to track on the work. You know, that's awesome. Well, I know so, but just keep an eye on the work. I don't like getting, I don't think like getting fines. That's not the position I want to push. Okay. All right. Yes, please response. Every week I have
Are you ready?
Yes, we're.
Do we need Mr. Muhammad?
He's on his way.
Okay. Okay, I can do that. Guess what I'm gonna offer you? June 5th.
June 4th.
You gonna
Say
do
June
no?
4th, I'll be here on time.
June 5th. I'll have her put June 4th. I'll have her put June 4th on the notice. We might as well set it for 12:30. And I'll continue bond.
Thank you.
All right, so Mr. Gregory, we're gonna get you a paper notice copy of this court date for next Wednesday at 12:30. Next Wednesday, 12:30?
No.
Mr. Gregory, you're still at the 1.082 Harrison?
Yeah.
Do you know what's going on with Harris, that motion?
Jamel Harris. So she said, I think she mentioned something about her not getting discovery, but it was sent.
No, but I mean, it's supposed to be 11:30. Is there an attorney out there to argue the
Yeah,
motion?
she's here.
Okay,
I'm ready.
all right.
There's a slight issue in the case.
We're good? Okay,
I'm sorry, that was 1:30, correct?
next week. The examiner just said
12:30.
12:30.
Right back here in front of this judge, Wednesday, 6/5, okay?
Enjoy your day, Mr. Gregory.
Thank you, appreciate it.
Hey, Mohammed?
Yeah.
Why don't you get the parties in on Harris?
Okay. I think we're still waiting for Detective Otter.
Okay.
He's the first one.
He's frustrated by the entire process. He's taking it out on them because.
Can you please, thank you so much.
We're good. We're good. Yeah. Well, you run into them once in a while.
Your course there can vouch for me.
Yeah. Yeah, he's been in trouble with everybody. Yeah. 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 Yeah, that's a dangerous combination. Yeah. Okay. All right. Have a good day.
But again, I always push it. Thank you.
See you next week. For this reason.
today, I got him in last week just because of the difficulty we had. But that is. Because you can't go anywhere without them. And don't forget, tomorrow morning we have those mineral items office to put it on the docket on your minutes at 8:30. I just throw a little.
What, do you know what it is?
It's a flash grid. You told Sandy that.
Oh, yeah.
Tomorrow morning at 8:30.
That's the one I said I didn't care.
Yep. I don't know if I want tomorrow morning is live Kristen. It's. What do you think?
Did you hear anything? Okay, I wasn't all like. Like he was thinking.
He sent me an email while we've been in here.
So then what's the Wall Street? My niece he's home so much that the other day, supposed to get lost. Send the text yesterday. So I just walk out. She walked into Gigi's. She was to go to my mom's house. They found my mom's house. So like, oh, yeah, absolutely, yeah. That education. Come on up to council table. We're ready for it.
Oh.
Just wait for Mr.
Yeah, Mr.
Muhammad.
Harris, come on. Yes.
What is your phone?
87128.
87128.
128.
She's got it done all. She'll make that work. She does. That's awesome. Yeah. Somebody check in.
Thank you. Oh, thanks. So we don't have to do anything.
I just don't get it out here, just so you can head up.
No worries. Thanks.
We probably don't need her. All right, appearances on Harris.
Good morning, Your Honor. Mohammed, P86771.
Good morning, Your Honor, and good morning to your staff. Alana Altler, P number 87128, on behalf of Mr. Jamel Harris, who stands to my right. Mr. Harris, could you please state your first and last name?
Jamel Harris. Thank you. Counsel, last name?
Altler, A-U-T-L-E-R.
A-U-T.
L-E-R.
Just how it sounds. Okay, thanks. All right, sit. Are we ready?
Yes, Judge. If people are ready to move forward, I'd like to request a mutual order of sequestration with an exception to the officer in charge.
Okay. Okay. All right, well, we're gonna do a motion first.
Okay, we can.
Yeah. So this is defense motion to dismiss.
Yes, that's correct.
Now, I understand you didn't draft the motion. You just kind of got stuck arguing the motion.
That's correct,
Okay.
Your Honor. I took over the case.
Okay. So first of all, with your acquiescence, I want to try to save us some time.
Okay.
So first of all, I think I remember this file correctly. I might not, but I think I remember that the last time I ordered discovery, we had the discussion about there might be a request to dismiss, and I explained to Ms. Phelps, this was hers, right? Yeah.
Yes.
I explained to Ms. Phelps my attitude about discovery. Because I think what's at issue is digital discovery, right?
Yes.
Okay, so I'm old. So I've been doing exams long before anybody had body cams. We did a lot of exams based on incident reports. So I'm very reluctant to tell the people they can't go forward with a probable cause hearing if there's been some digital discovery that hasn't been exchanged. I just want you to, because I know Ms. Phelps has heard that from me before.
Yes.
I wanted you to know what you're up against.
I hear you.
So the only way I'm going to dismiss this today is you got a high bar. You're going to have to convince me that you being the defense, have been so damaged by the not having digital discovery that they can't prepare a defense for a probable cause hearing, understanding this is not the trial.
Understood.
And I know you know that. I just want to make sure Mr. Harris understands where I'm coming from.
I've explained that to him as well.
Okay.
And Judge, I just want to state for the record, after that previous hearing, we did send digital discovery, which included 17 pieces of digital evidence that was sent to defense counsel. And that includes the body worn cameras of the officers. I think what's at issue here is what the defense attorney told me prior to walking in here is that there's a video from a scout vehicle that may have digital or a camera attached to it. Was my understanding. Please correct me.
I mean, I'm happy to argue it as well,
Sure.
Judge, if we just want to cut straight to the
That's
chase.
fine. That's fine.
Yes. Sure. So of course, we are moving to dismiss based on the prosecution's failure to comply with your discovery order, which was signed for May 3rd. I won't rehash the facts of everything because the court is in receipt of the motion, but the court entered an order to produce outstanding digital discovery by May 3rd. On May 20th, is when defense counsel received digital discovery, including those 17 portions of 17 items Mr. Mohammed referenced, but that's not entirely responsive to what we requested. And notably, we were still missing and continue to miss several items. Number one, scout footage from Officer Green's vehicle, which is relevant because it transported my client to DVC or the jail for that jurisdiction. That is important because it could potentially contain statements made by my client, which would then fall under MCR 6.201B, which means the prosecution must hand over any sort of recorded statements by my client. Secondly, we are also missing the body-worn camera of Officer Riblet, who assisted in the search of our client, which is again very relevant because the search allegedly yields some items that are at the heart of these felony charges. So because of this, we're also arguing that that body-worn camera footage could be exculpatory because it determines whether his Fourth Amendment rights were violated. So even if this prosecutor is unaware of whether this evidence exists, Your Honor, he is still responsible for providing it under Kyle's as well as Chenault. This is, again, an issue with the Michigan court rules because the court rules state that this discovery needs to be provided within 21 days of request. I think defense has been more than flexible in waiting for this. We have a signed discovery order from May 3rd. 27 days have passed since the court's order and 38 days since that order was filed on April 22nd. And finally, Your Honor, not to belabor the point, but Mr. Harris, I believe, has a due process right to obtain this evidence. It is favorable to the accused and material to his guilt or innocence under Brady. And the Supreme Court has expanded the Brady doctrine specifically to include materials that could reference impeachment. And impeachment is an issue that comes up at exam. Impeachment could refer to both of these items we are looking for, the scout car footage as well as body-worn camera footage. And we need to be able to see those in order to properly impeach. So therefore, Mr. Harris is entitled to dismissing discovery under both Brady due process rights and the Michigan court rules.
Now it's your turn, Ms. Moore.
Judge, we don't even know if the scout vehicle digital even exists. I just spoke to the officer in charge who's here in the courtroom and he showed me what he had, which included, it looked like 11 to 12 pieces of digital. We sent defense 17. They uploaded everything onto evidence.com. We sent it to defense counsel. Them citing something about a scout vehicle, I don't see anything in the report that suggests that there's another video that exists. Sounds like it's just speculation. And so I'm objecting because there's no foundation to what she's requesting. If there's something that says in any of these documents that says that the scout vehicle for Officer Green exists, I asked her prior to walking in here to show it to me so I can show it to the OIC. Nothing was presented. So it sounds like it's just speculation. So I'm gonna object to the motion to dismiss for that reason. I'm also gonna object to it because discovery is an ongoing thing. So it doesn't start and end here at exams. It can continue all the way up to trial, is my understanding. So they have enough, I believe, to move forward today. They have body worn cameras. So I believe this subject is closed. I think we've met our standard of what we have to show for this case to move forward.
Ms. Holder.
If I could just respond real
Sure.
quickly, because he did reference speculation here. In the paper discovery, we have page 15 of the police report indicates that Mr. Harris was transported in the back of Officer Green's vehicle to jail. So we know that that is what we are looking for. Additionally, because we received other scout car footage clips as part of discovery, we know that Romulus PD does have recording devices in these cars. So that is every indication that that video exists. So I would say that this is not speculation. Furthermore, yes, while they did send 17 pieces of discovery after the court order asked for it, that doesn't necessarily mean it's responsive to what we are asking for.
And just very brief response.
No, not yet. How is it not responsive?
Well, after we received the 17 pieces, I went back to Mr. Mohammed and I said, here is what we are still missing. So I did outline those things as a show of good cause and due diligence.
Other than the green squad car video, what else was missing?
The body worn camera footage of Officer Riblet as well as Officer Otter, but I understand that sometimes sergeants do not wear body worn cameras.
Okay.
So we are willing to
Okay.
look over that.
Okay, now it's your turn.
And Judge, I'll just state that the OIC is here in the courtroom. If I'm asking him if it's in his possession, at some point turn it over to the office and we'll send it immediately to defense counsel, if it exists.
Okay.
For the scout vehicle footage of Officer Green, and if Sergeant Otter's body worn camera was activated during this interaction.
And another body cam, Officer Ridlin?
Riblet, yes.
Ridlin. That's a new name for me. Otter has no body cam.
Sergeant Otter, Your Honor, with that body cam.
Okay. Officer Ridlin, maybe.
Ridlin is who?
He doesn't know who that is.
He's not one of ours?
He's
That's why
Inkster PD.
That's why I don't know the name then. Inkster PD?
And what was his role in this?
He performed part of the search for Mr. Harris.
That was Officer Christopher Cozero.
He assisted. Again, I'm just going off the information that was given to us in paper discovery.
Okay. All right. Okay, I'm going to deny the motion, counsel, because I think all these things, all of these are arguments you can use for the trier of fact before the trial. As once again, this is a probable cause hearing. I think there's enough information that's been exchanged to have a probable cause hearing.
Understood, Your Honor.
So are we ready for that?
Yes, Judge.
All right, let's go.
So I'd like to introduce pursuant to 76611B, a MSP lab report that shows that the drugs recovered from the defendant in this case tested positive for cocaine. One of the items was for 1.493 grams, the second was for 0.501. This was sent to defense counsel and I'll present it to them now.
Thank you. That'll come in. Appreciate the stipulation.
And Judge, in regard to the defendant's previous conviction, I think what happened is I had the folder for this case and I forgot the folder at home. I was reviewing this case last night and the previous conviction, the felon in possession that was certified by the clerk at the Frank Murphy, it just left at home. So I'm going to respectfully request a held in part just in regard to presenting that certified conviction for the FIPs in regards to this case and the felony firearms that attached to it.
Your Honor, I would object to holding this in part in adjournment. Counsel was aware of the date of this preliminary exam. So without the certified records, I do not believe the charges of FIP and the accompanying FF charges are appropriate.
I agree.
Then I would cite to the Michigan rules of 766.4, which speak to scheduling and commencement of an exam and require that the examination must be completed within the time frame of 14 to 21 days. And we are here ready to begin. And it's just.
No, let me stop you. Let me stop you. I'm not saying we can't do the exam. I'm saying I'm not going to let you fix one of your charges because you forgot something today. So we can go forward with the other charges, but if you can't establish one of your charges because you left something at home, that's going to result in a dismissal today. And then you can appeal me because circuit court judges need to eat too.
Your Honor, may I have a second?
Sure.
All right, Judge, we're going to move forward.
Okay, call witness.
The people called Detective Otter.
Thanks, Ken. Detective up front, please. Raise your right hand. Swear affirm, tell the truth, whole truth, nothing but the truth today. Settle in. When you're ready, Mr. Mahoney.
Good afternoon, Detective.
Good afternoon.
Can you please restate your full name for the record?
Yep, it's Jason Otter, O-T-T-E-R.
Detective Otter, are you currently employed?
Yes.
And who is your employer?
Romulus Police Department.
And in what capacity are you employed there?
I'm a detective sergeant.
Okay, and were you working in that capacity as a detective sergeant on April 4th, 2024?
Yes.
And did you work this date by yourself or with a partner?
No, I was solo.
Okay, and on this day, did you work in full uniform or modified uniform?
It is a modified uniform.
Can you give a brief description of what that entails?
So it would be kind of a polo shirt like this, only it would not have the arm patches here. It wouldn't have the stripes here. It would just say like detective on here. And then I had a exterior vest, like a ballistics vest.
Okay.
And that would say, it would have my name on one side, it would have police on the other, and then it says police in big block letters on the back.
Okay. And on this day, were you working in a scout vehicle or on foot patrol?
Neither one. I was actually in a unmarked car.
Okay. And so did your duties as a detective sergeant take you at or near the location of 31222 E-Course?
If that's the address for Bar 101, yes.
Okay. And was that located in the city of Romulus, County of Wayne?
That's correct.
in regards to the location, would referring to your report refresh your recollection as to the exact street address?
Yes, it's gonna be in there.
Sure.
Detective, please refer to the report and refresh your recollection. Your memory's been refreshed. Just look up at me and let me know.
Yes, that's correct. That is bar 101.
Okay, so 3122 Ecorse Road in the city of Romulus, County of Wayne is where you were at.
3 twos.
Yes, 3 twos. Correct. My apologies. And what took you to that location?
For that particular day, we had a special detail. There was a, I guess I don't want to call it an after party. I forget what the technical name they use, but basically there was a funeral in another city. And this was when they were having like the dinner, after the funeral.
So you were on like a special attention detail?
That's correct, due to the nature of the reason for the funeral.
Okay, and were you assigned to a specialized unit on that night or on that day?
Just the detective bureau.
Okay. And while at that location, did you observe something that drew your attention?
Yes.
Okay, now what drew your attention?
So where I was sitting was in again, in an undercover vehicle. I was tucked in with some other vehicles. We were watching the parking lot of bar 101 for when people filed out from the event. There was a lot of people gathering, crowds gathering, and we were there to make sure nothing went awry, basically.
Okay, and what did you observe?
A couple cars in front of mine where I was parked, there was an SUV. I observed a small gathering of people. I believe it was about 4 different people, 2 males, 2 females, gathering right in front of me.
And did any of those individuals draw your attention?
Yes.
Okay, that individual that drew your attention, do you see that individual in the courtroom?
I do.
Can you please point to that individual and point out an article of clothing that individual is wearing?
Be the gentleman here. He's got a green shirt with a white shirt underneath.
Noted.
Thank you. And what about this individual drew your attention?
He was wearing a hoodie. His jeans he had jeans and a hoodie on. He had like a ski mask almost. It wasn't all the way up. I can't remember, they call him like a balaclava or something of that nature. And which was kind of strange, and he kind of was wobbling as he was walking, to what drew my attention to him initially.
Okay, and so upon that observation, what, if anything, did you do?
As I was watching him, it looked like in his right pocket, pants pocket, right front pants pocket, it looked like the butt of a gun, like what the magazine portion of a firearm. So then that obviously drew my attention even more.
Okay, and can you describe exactly what you saw? So you said you saw the butt of a gun. Now, did it appear to be inside of his, was it concealed in any way based on your observation?
Yeah, it was concealed inside of his pocket. Again, his pants pocket, the right front pants pocket.
Okay, now when you observed this, along with the other stuff you mentioned, what did you do?
So I wasn't 100% sure. So I began recording just to see what was going on, seeing what the interaction was. I began recording with my department issued cell phone.
Okay, and did you see anything else?
There was some conversation between the groups, and it looked like they were friendly. It didn't look like it was a bad altercation. And then that gentleman walked into the liquor store.
Okay, when you were recording him, did you see the gun differently in any different angles or anything like that? Or?
I couldn't see it from the live view. My eyes, no, I could not.
Okay, and so you stated that individual went inside of the gas station?
As a liquor store.
Or the liquor store?
Correct.
And then what happened next?
So while he was in the liquor store, I started to review the video that I just recorded, where I could zoom in and get a better view.
Okay, and did you learn anything?
When I looked at the video, it appeared like he was showing the other people something, and I actually saw his right hand go in his pocket and pulled out what looked like a firearm on the video.
Okay.
A handgun.
Okay, and what did you do upon confirming that?
So then I radioed I actually saw him coming back out of the liquor store, only this time he had his ski mask up over his, covering his whole face. He also had sunglasses on, and then his hoodie, he had a hoodie as well. And he started to walk towards bar 101. So then I got on the radio to radio other officers to see if anybody else could see him or had eyes on him.
Okay, and what did you do next after that?
So unfortunately, nobody had eyes on him. When I got out to try to look, we couldn't find him initially. And so I had lost sight of him.
Okay, and at any point during your stay at that location, did you observe the defendant again?
I did.
Okay, and where did you see that individual?
We eventually made the determination to clear the parking lot. It started to get where there was some issues happening. As we were clearing the parking lot, I was out on foot. I observed the same subject across the parking lot. I was up by the liquor store. He was across the parking lot, closer to bar 101.
Okay, and when you saw him the second time, what did you do?
So there was another officer near me, so I.
Which officer, if you recall?
Shabel.
Okay.
And I told him, hey, Dan, that's the guy that's got the gun. So we started to proceed over, and I'm not 100% sure if I called it on the radio, but I believe I did.
Okay, and then what did you do when you started making that individual's location?
As we were walking towards him, I observed him to start walking, what would be south along the building.
Okay.
Bar 101 building.
Okay, and did you make contact with the defendant?
At that point, no. I lost him in the crowd. Again, it was like a large parking lot, a bunch of cars, bunch of people. So as we were trying to maneuver through, he kind of looked like he disappeared. I thought he actually went into the building.
Okay, and at any point during that interaction, did you regain eyes on that individual, on the defendant?
Eventually I did, yes.
Okay, and how did that occur?
So again, by that time I had definitely radioed to the other units a description again where he was last going. Somebody said they saw him. It looked like he was turned the corner of the building. So that's where I walked. And as I went around the corner of the building, did not see him anymore. However, there was a vehicle coming out to exit the parking lot and driven by a female. There was a young child in the front, and the gentleman that I was looking for was in the back seat of the vehicle.
Okay, and is that same individual you identified here in court today?
That's correct.
Okay, and when you saw him in the back seat, what did you do?
The lady was stopped because she couldn't get out of the parking lot. She was coming like from a side angle, and there's other cars filing out normally. So I knocked on the hood of the car. She rolled the window down. I told her to stop the car, shut the car off. I alerted the other officers who were standing by that this was the guy we were looking for.
Okay, and what did you do next?
Then I opened the back door to the car, which would have been the passenger side, which side he was sitting on, and ordered him out of the vehicle.
Okay, and why did you order him out?
To try to get the firearm that he was possessing.
Okay, and did you recover a firearm from that individual?
I personally did not.
Did you observe anyone recover it?
Correct.
Who did you observe recover it?
Officer Coziera.
Okay, and where did you observe that officer recover the firearm from?
So when we first got him out of the vehicle, I grabbed a hold of one of his arms. Officer Coziera grabbed the other one. Once the subject was put into handcuffs, then I asked Officer Coziera to take him to the rear of the vehicle, pat him down, search him, and then I addressed the driver so she didn't drive off on us.
Okay.
And that's where he recovered the
firearm. Okay. Did you see where he recovered it, or did you not observe that? Like where on his person Officer Coziera recovered the firearm? Did you observe that?
I did not, because I was addressing the female.
Okay. Do you know if that individual? Okay. Well, when you first saw the individual in the passenger in the back, did you observe the firearm in plain view anywhere?
No.
Okay. All right. Now, did that individual, the defendant, present to you, or did you observe him present it to Officer Coziera a CPL license?
No.
Okay. Did you perform any kind of searches to confirm the defendant didn't have a CPL search or a CPL license?
Yeah, we conduct a lien search. Is that what you're referring to?
Yes.
Yes, correct.
Okay, so a lien was confirmed the defendant did not have a CPL?
That's correct. He did not possess a valid CPL.
Objection. I just Can he only speak to what he personally observed? I don't know if he
That's
can.
fair clarification. Sergeant, did you do the lien search yourself?
I do not believe I did.
I'm just.
That's all right.
Would referring to your report refresh your recollection as to how you learned whether the defendant had a CPL license or not?
Yes.
Your Honor, may I approach?
Sure.
Has your memory been refreshed?
Yeah, so again, I did not complete the search myself.
But what did you do?
So when we have a subject like that, we ask dispatch to run them, and then dispatch generally performs that.
Okay, and upon learning that information, what did you do when you learned that
Objection,
information?
lack of foundation.
What its effect on the listener? It's why the defendant was why they were arrested.
Response.
Your Honor, if he's referring to the contents of what dispatch told him, that is hearsay. We can't just skip over the contents of that and go immediately to what happened to the effect on the listener. We're talking about the substance of what is being said here and communicated. It's being used for the truth of the matter. If it's being used to say, we're going to charge somebody with a crime, that's for the truth of the matter, and that's hearsay.
If you're trying to establish the reasons that the sergeant did what he did, I think that's fine, but I don't think you can use hearsay to establish an element of the crime.
But the statement, which let's say it is hearsay, is being used to show why the officer conducted an arrest. Now, if he doesn't have that statement, he's not affecting and he's not doing an arrest, because that statement is what it makes that effect on that individual to conduct an arrest. So it meets.
I agree with you.
It meets the classic definition of an exception or exemption
It
to
does,
hearsay.
but you still have to establish that he illegally possessed a weapon. That's part of what you have to establish today for the probable cause here. You can use the hearsay to establish what Officer Otter did, but you still need to prove to me that he didn't lawfully possess the weapon that day to get past the probable cause here. And you can't use hearsay for that.
I guess I'm just not following what you're saying exactly. So he had a firearm concealed on his person. That individual did not produce a CPL license.
Which you have to establish today with something other than what dispatch told the sergeant.
But I did by the statements of Sergeant Otter stating that the defendant never produced a CPL
But
license.
he only knows that because somebody else told him.
Okay, I can lay a better foundation as to those questions.
Okay.
But in regard to this, in regard to the lien search, is it gonna be admitted statements?
That's what she's objecting to. I'm assuming.
Yes,
Is the lien report.
that's correct, Your Honor. I object.
Her objection was you haven't laid a proper foundation to get the report admitted into evidence. I think.
I'm not admitting the report.
Okay, then I'm confused. What are you trying to do?
So I'm just introducing the statement from the individual that gave.
Yeah, I told you, you can use hearsay because your hearsay objection is, I just want to prove why the sergeant did something because he was told something. I'm okay with that. I don't think she's even objecting to that. But at some point today, if you want him on a concealed weapons charge, you're gonna have to establish that he was not authorized to carry concealed, and you're gonna have to do it with something other than somebody did something and told somebody else about that something. Because that's hearsay.
Okay. Oh, Sergeant Otter, did you make contact with the defendant in this case?
Yes.
Okay, and why was, okay. Did the individual produce to you a CPL license?
He did not.
Okay, did you ask him for one? If you recall.
To be honest, I don't remember if I specifically asked that.
Okay, and so the individual was arrested on that day, correct?
Correct.
What was the basis of the arrest?
There were multiple reasons, but one of which he was intoxicated. When again, from my observations watching him prior to contact, he was unsteady on his feet. He had alcohol in his hands, which open alcohol, beer bottle. He's drinking that. When I made contact with him, when he was in that vehicle, there was a very strong odor of intoxicants coming from the vehicle and his breath as he was talking to me. His eyes were glazed over. He also had open liquor bottles right next to his person.
And besides,
was in possession of a firearm at that point.
Okay, but what about the possession of a firearm? Is it illegal to just carry a firearm? Or is there something that goes along with it?
It's illegal to carry a firearm concealed. Yes.
Okay, and
If
did you
don't
observe
have a permit?
Okay, and did you observe the firearm concealed?
The firearm was definitely concealed.
Okay, and how do you know that?
It was in his pocket to where it was not visible.
Okay.
To the naked eye. He was also inside of a vehicle at one point, which again falls under the definition of concealed.
Yes. Okay, and when you made contact with that individual, did they at any point present to you a CPL license?
No.
Okay. Your Honor, respectfully, I believe if an individual is carrying a firearm, especially in a vehicle, as soon as they get stopped by police, they have an affirmative duty to disclose that CPL. That's my understanding, part of the rules. The defendant failed to do that. The defendant also did not produce one. Also, the sergeant testified that he made contact with dispatch and they confirmed via lien the defendant does not have a CPL license. I believe for purposes of a probable cause standard, I believe the testimony reflects at this point.
I think the rules require in a traffic stop situation, I believe the rules require the CPL holder to immediately, I'm not sure that's the word, inform the law enforcement officer.
An affirmative duty. And so I believe we've met that.
We'll save that argument for when we're done with the exam.
I understand.
Okay, go ahead.
Okay, thank you all, Sergeant. Did you recover or observe anything else personally?
Just again, from what I've stated already, no.
Okay. The firearm, did you recover it or did you observe the firearm?
I did. Officer Cozier showed it to me.
Okay, can you describe what the firearm that you saw?
It was a black handgun. I'm sorry.
Okay, do you know if that firearm was loaded?
I didn't unload it or check the bullets.
Okay, nothing further from this.
Cross, counsel.
Good afternoon, Detective.
Good afternoon.
You were called to this location to monitor the parking lot, correct?
We weren't necessarily called, we were assigned to it. It was something we knew was going to happen, and we were trying to take proactive action instead of reactive, so.
So you were observing the scene?
Correct.
And there were a lot of people there?
There was.
Dozens, safe to say?
Yes.
Okay. So let's talk about the first time you observed the individual you were talking about. You saw several people near a vehicle, correct?
Yes, correct.
And that vehicle was 2 cars in front of you?
I believe it was the second car in front of, like one buffer vehicle, I believe.
So you were in your vehicle at the time?
Correct.
And how many feet away from this person were you?
I would guess maybe 15 to 20 feet, something, whatever a car length would be.
And this person's back was turned towards you?
No, he was like moving. So sometimes yes, sometimes no.
You could not see his face clearly at this point
No, I could see his face.
and intermittently.
Again, at times, yes.
At times.
Not the whole time, no.
And according to you, you saw a black object in his right front pants pocket. Is that correct?
That's correct.
Okay. But you couldn't confirm what it was at the time.
Not 100%, no.
You even wrote that in your report, correct?
I believe so.
That you weren't sure what it was.
Correct.
Then you eventually lose sight of this person as you
Well,
testify.
he walked into a building, so yes,
Okay. And then you see this man at other points throughout the evening, correct?
that is correct.
And at one point, he's wearing a face mask
Yeah, it's again, like a ski mask type,
and sunglasses.
and sunglasses, yes,
So later that night, you ordered a car to stop, correct?
that's correct.
Okay. Because you believed you saw the person that you had spotted earlier in the car,
That's correct.
in the back seat, correct?
Yes,
This person was not driving.
he was not driving.
Okay. So you ordered the driver to shut off the vehicle.
Yeah, at one point, yes.
Yeah.
I don't know if those are my initial words to her, but
And she did.
she complied, she was compliant.
So it's safe to say that the occupants of this vehicle were not free to leave in this moment.
That's correct.
So then you ordered the man out of the back seat, correct?
Yes.
And you helped place him into handcuffs.
I'm sorry, I did what?
You helped place him into handcuffs.
Yeah, I assisted with the arrest, correct, or the handcuffing, I'm sorry.
So to clarify, you did not pat down Mr. Harris.
I did not, know.
Okay, so you didn't recover a gun.
I did not.
You didn't recover any other contraband.
I did not.
Okay, and you did not run the lien search on this individual, correct?
That is correct. I physically did not.
Officer
I
Rhodes.
requested it, but I did not run.
Officer Rhodes ran the lien search.
Yeah, she's a communications officer, so
Thank you. You had never met Mr. Harris before this day.
not to my knowledge.
Okay. You didn't know at the time whether he was a convicted felon or not.
No.
You were not wearing body worn camera footage on this, body worn camera
I'm
on this
sorry?
day? You were not wearing body worn camera
No,
on
I
this
wasn't.
day? Okay, and your vehicle was not equipped with a dash cam
Correct.
this day? No further questions.
Any redirect of the sergeant?
Nothing further.
Can we send him back to whatever he should be doing today? All right. Thank you, Jason. Be safe. Watch your step. Next witness, Mr. Muhammad.
People called Officer Cozier.
Would you send him in, please?
Yep.
Officer, all the way up front. Raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth today? Come on up, settle in the chair, watch your step on my ramp. Mr. Muhammad, when you're ready.
Good afternoon, officer. Can you please restate your name for the record?
Christopher Coziera, CHRISTOPHER, Coziera, KOZIARA.
Officer Cozier, are you currently employed?
Yes, I am.
And who's your employer?
City Ronos,
And in what capacity are you employed there?
police officer.
Okay, and were you employed in that capacity as a police officer on April 4th, 2024?
Yes, I was.
Okay, did you work this date?
Mr. Muhammad, give me a minute.
Okay.
You got a search warrant? Raise your right hand. Swear affirm that the information contained in the affidavit is true, the rest of the information I believe. Send me the email. I'm in the middle of an exam. I'll take care of it when I can. Yep, be safe. Sorry for the interruption. Go ahead, Mr. Muhammad.
Apologize, I'm trying to remember where.
Sorry about that.
It's okay. Do you recall my question?
Yeah, was I working that day?
Okay, yeah, were you working on that day?
Yes, I was.
Okay, and just to confirm for the record, because we did have a brief stop, that was April 4th, 2024.
Correct.
Okay, did you work by yourself or with a partner?
With a partner,
What's the name of your partner or partners?
Officer Reyna.
Okay, and on this day, were you working in full uniform or modified uniform?
Full uniform.
Okay, were you operating a scout vehicle or on foot patrol?
Scout vehicle,
Okay, and was this scout vehicle fully marked or semi-marked?
fully marked.
Okay, and did your duties as a police officer on April 4th, 2024 take you at or near the location of 31222 E-Course?
Yes, sir.
Is that located in the city of Romulus, County of Wayne?
Yes, it is.
What took you to that location?
A large gathering that became a fire hazard.
Okay, and did something at that location draw your attention?
Yes, it did.
What drew your attention?
Not only the large gathering, but at one point Detective Sergeant Otter requested my assistance.
Okay, and as part of your assistance, what, if anything, did you do?
I assisted him in grabbing a hold of a mail.
Okay, that individual, do you see that individual in the courtroom today?
I do.
Can you please point to that individual and point out an article of clothing that individual is wearing?
Green polo shirt.
Your Honor, please let the record reflect the witness has identified the defendant.
Noted.
Thank you. And what did you do as part of that assistance when you were in possession of this individual?
I started with grabbing a hold of the male's left arm. He was eventually exited the vehicle, the back seat of a vehicle. At that point, I detained him.
Okay, did you recover anything from this individual?
I did.
What did you recover?
The first item I recovered was a black Glock.
Okay, this black Glock, where was it located on this individual's person?
His front right pant pocket.
Okay, was it inside or outside of his pocket?
Inside.
Okay, and can you describe what this firearm looked like?
Black Glock pistol.
So I'm not familiar with guns, so can you describe what a Glock is?
It's a brand of
Okay,
firearm.
got it. And you said it was a pistol?
Correct.
Okay, was this firearm loaded?
Yes, sir.
What was it loaded with?
10 millimeter rounds.
Okay, and what did you do when did you make it safe?
Once I recovered the weapon, I handed it to Detective Perkins.
Okay. Did the individual you recover it from at any point present to you a CPL license?
No.
Did you ever ask him for one?
No.
Okay, and this individual, you stated you got him out of a vehicle, correct?
Correct.
Okay, now, besides the firearm that was loaded with bullets, what else did you recover, if anything?
Suspected narcotics.
Okay, now where did you recover those narcotics from?
Pant pocket. I would have to refer to my report.
Okay. Thank you. Your Honor, may I approach the
Sure.
witness with this report?
Yep.
And so you can just read it and review it and refresh your recollection. When your memory's been refreshed, just look up at me and I'll go from there.
He's ready.
Where was that suspected drugs recovered from?
Male's left front pocket.
Okay, and can you describe what it looked like, what you saw?
It was marijuana, multiple baggies of that.
Multiple baggies of what?
Marijuana.
Okay.
Multiple baggies of suspected cocaine.
Okay.
Objection, speculation, Your Honor. He's not, unless he's been qualified as an expert in drug analysis, then I object to that.
Yeah, just have him describe what he saw.
Yeah, so just describe what you saw, like whether it was, in a bag or just not what it is. You can say suspected. Can he say suspected drugs?
If that's what he suspected.
Yeah, like if you say what you suspect, but just don't say what it is, 'cause at that point, I'm assuming you didn't know. Okay.
Individualized bags with white powdery substance.
Okay, and based on your training and experience as an officer, what did you suspect it to be?
Narcotics.
Okay, and how many did you see, if you recall?
There was multiple bags.
Okay, now these baggies, what did you do when you recovered?
After I completed searching the mail, I found or retrieved evidence bags for my patrol vehicle.
Okay. And did you place that stuff into evidence?
I did.
Okay, thank you. And all this was recovered from this individual you see in the courtroom today, the defendant?
Correct.
That you identified here in court today?
Yes, sir.
Nothing further.
Zolder, your witness.
Good afternoon.
Good afternoon.
So you approached a vehicle during this day, correct?
Correct.
And that vehicle contained who you believe to be Mr. Harris.
Correct.
So before you approached this vehicle, you had not personally observed the person inside the vehicle, correct?
Correct.
You had not seen him committing any crimes in the parking lot.
Correct.
You had not seen him holding what appeared to be contraband before.
Correct.
You walked over to the vehicle in question, correct?
Yes.
Because you received a call over dispatch, correct?
My detective sergeant requested help from officers on scene.
Yes. He had said, hey guys, give me a couple of units, correct? Yeah. And you help remove a man from the car, correct?
Correct.
And you pat him down,
Correct.
basically because Sergeant Otter told you to.
Yes.
So according to you, you were standing behind the man during the pat down.
Correct.
And you were able to see into his front pocket.
Based on how I positioned my body behind his.
And, okay. So then you recover a firearm, correct?
Correct.
Okay. And then you continue to pat him down after you recover the firearm.
Correct.
To ensure there were no other firearms on him, correct?
Correct.
Okay. And there were none.
Correct.
So this part of the pat down happened behind the vehicle that was stopped, correct?
Correct.
And then you moved Mr. Harris to another location, right?
Yes, I did.
Okay, in front of the vehicle.
A patrol vehicle.
And you continued to search him at this point.
Correct.
Okay. At this point, you had not checked a lien, correct?
Pardon me?
You had not checked a lien at this point.
Lien, no.
And Mr. Harris was not formally under arrest at this specific moment.
He was being detained.
But not specifically under arrest.
Sure.
So that's a yes?
I mean, we had at least the violation for being intoxicated if he did have a CPL at that point.
But you didn't know if he had a CPL at
Correct.
that point?
I did not know.
Okay. So let's talk about that additional search that you performed. You went into this man's front left pocket, was it?
Correct.
Okay. And you pulled out a sandwich bag of sorts.
Yes.
Okay, that contained a substance.
Correct.
Okay. You did not perform a field test of the substance?
No, I did not.
Okay, and you didn't perform the lab test either?
No, I did not.
Okay. You're not certified as an expert in drug analysis?
No,
Okay. You had never met Mr. Harris before this day, correct?
I have not.
You didn't know whether he was a convicted felon?
No,
And when you recovered that firearm, you were not wearing gloves, correct?
I don't recall. I'd have to watch the body cam, see if I had gloves on or not.
So you can't recall if you grabbed it with your bare hands?
Correct. I don't recall.
Okay. No further questions.
Any redirect?
Okay.
You said no. Watch your step. Can we send the officer back to his duties?
Yes.
Be safe. Next witness.
People call low IC Detective Rice.
Raise your right hand, swear affirm. I just swore Dale in, so now I want to do a search. Swear affirm to tell the truth, all truth, nothing but the truth today. Thank you. Ms. Mohammed, when you're ready.
Good afternoon, Detective. Can you please restate your full name for the record?
Full name is Goff, Goff, Rice, Rice.
Detective, are you currently employed?
I am.
And who is your employer?
City of Romulus,
And in what capacity are you employed?
as a
There.
police officer.
Okay, and how are you associated with this case?
I am a detective currently at Romulus, and I am the OIC of this case.
Okay, and as part of your duties as the OIC in this case, what did you do? Was there any specific assignments that you conducted?
So prior to, once a defendant in this case or any other case is arrested, I conduct a investigator's report, put it together, submit that to a prosecutor, then approves charges, if any.
Okay, and as part of that, as part of putting that case together, besides the investigator's report, is there anything else you do?
I backtrack what officers did to make sure everything's completed. In this case, I reran or verified lien work, verified the firearm registration, just overall the components of the alleged crime before submitting it and putting it pen to paper.
Okay, and as part of composing those documents, such as the lien associated with that case, would you be able to identify that information if you have it presented?
Correct.
Okay. Your Honor, may I approach the defendant?
Sure.
Or my apologies.
Could be.
The witness. Detective, I've handed you what is People's Proposed Exhibit number 1.
Your
Now,
Honor,
that
for the
doc-
record, I did object to to this. I just
Okay.
want to make a record of that.
Yeah,
I didn't know
well,
if you heard me.
Say that till he tries to admit it.
Yes.
Go ahead.
Detective, I've handed you what's People's Proposed Exhibit number 1. Now, do you recognize that document?
Yes, sir.
Okay, how do you recognize that document?
This is a page of lien work associated with the defendant. And what it shows is their criminal history. And in this case, this shows that on 1/16 of 2020, he was convicted and pled guilty to a felony home invasion.
Okay. To the best of your knowledge, does that document fairly and accurately depict that lien that you performed or reviewed in regards to this case?
Correct.
And to the best of your knowledge, does that document appear to be altered or manipulated in any way?
Only alteration is myself that I just made today, an ink pen that I wrote. That's the only alteration.
Okay.
I made that today.
In regard to the document itself, is there any words or anything that appears to alter anything besides the line that you had written
No,
on it?
no, sir.
yourself?
No, sir.
Okay, Judge, the people would like to introduce People's Proposed Exhibit number 1 into evidence.
I would object to this, Your Honor. First of all, it's unclear for what purpose this is being used for. A lien search typically shows whether or not someone is prohibited from having a CPL or has a CPL. What I reviewed on that paperwork does not show that. It shows a prior conviction. If APO Mohammed wanted to admit that, it would require a certified record. So any sort of evidence that he has previously been convicted of a felony is improper if it is not a certified record.
So what, hold on, I want to make sure I understand your objection, so I know what you're responding to. What is your objection?
My objection is that this is hearsay. This is essentially hearsay. Again, I think there's a lack of foundation here as to whether or not this officer performed the lien search.
Okay, so 2 different objections, handle them either way you want.
So it is not hearsay. It's the document itself that's the document that the officer printed associated with it. It's the actual document itself. So I don't believe it's not an out of court statement. It's the actual original. I don't know if it's the original, but it's a printed version of the document that the officer is testifying to. Also, it's being introduced into evidence. It's not something somebody's testifying to. So he's not testifying saying somebody said this, somebody said that. It's not a person. We're actually introducing this into evidence. It's an exhibit. So I don't think hearsay applies. And as far as a better foundation, I believe the foundation's been laid. The officer testified that as part of his duties, he, conducted putting together investigator's report, getting documents such as this. He testified that this is the fair and accurate representation of that document. He testified that it doesn't appear to be manipulated or altered in any way besides
Let
what
me
he
stop
did.
you because I'm not clear based on the testimony. Did you do a lien search and that was the result? Or did you look at somebody else's result of a lien search and say, that looks like a lien search?
So, Your Honor, I don't recall if I pushed the lien button myself and printed it off. What I do is take, if Mr. Mohammed is the arresting officer, he has a lien search ran, he then brings me the certified copy, which from our dispatch, it says, hey, here's what he has. I in turn take this lien document, I submit that down to the Wayne County prosecutor, which this is what they require, is this lien, whether I ran it, he ran it, they just require what's called a CCH. They require that. So sometimes I do rerun them myself. I don't recall in this instance if I ran it myself or not. Like, I don't want to tell you that I pushed print on this one, if that's what you're asking.
Okay.
But I did review it multiple times. And I did submit one of these copies of his CCH to the Wayne County prosecutor.
And counsel, hold on. Counsel asked a question that we just glossed right over. What are we admitting this for if we admit it?
Okay, so also I just wanted to state before I get to that this document was in the officer's possession. It was the OIC's version that was brought to court today, just so clear on that.
Record's
it's not
clear.
something I brought. Second of all, it's part of their jacket, is my understanding. Second of all, the reason it's being introduced is because it's going to show that in the year 2020, the defendant was convicted of, or he pled guilty to home invasion.
Then it's being offered for its truth.
Yeah.
And I object because that's your
Can I make my statements? Like, I don't interrupt when you're speaking. So please.
Fair enough. Go ahead.
So it's being introduced to show that the defendant has a previous conviction of home invasion in the 3rd degree, which is a felony. He pled guilty to it on January 16th, 2020.
But isn't a certified record required at preliminary exam?
It's the ideal way to do it, but there's other ways. I mean, the certified record of actions is just another way, in my opinion, to do it through 76611B. It's so convenient to the court, to the witnesses. Sometimes we don't have people who, can testify to it. It's just a very quick way. This is more of the longer approach, in my opinion. I have an officer who's testifying to having it in their possession. It's part of this case. It's the OIC of this case, saying that this individual previously convicted in 2020. So it's just a longer approach. It's not the ideal way. But I think I don't see any reasons why.
Let me give Ms. Alter a chance to respond to that.
Of course.
I agree that generally speaking, we've got a certified copy. Is there a requirement for a certified copy? And if so, where from?
Typically, what we do is that if there is an argument for bind over for certain charges based on felon in possession of certain items, it requires a certified copy of conviction. That is not a certified copy. That's a printout from the computer.
But that's not my question. I know typically, I mean, I've been doing this a long time too. Typically, we see a certified copy. Is there some court rule or statute that requires that bind over that there be a certified copy, or can the trier of fact, the gatekeeper, establish that from some other method?
I believe there is a statute on point, Your Honor. I don't have it with me. If I'm given a chance to look, I can.
I don't mind giving you a few minutes if you want to play on your phone.
Sure, I'm happy to look into that.
I don't know. I just know generally we got the certified copy. You want to do that now?
I can do that now.
Go
Yes,
ahead.
give me a few moments.
Go ahead.
And Judge, I normally would have it.
No, I know. You forgot. Stuff happens. So take a break.
Thank you.
I'll get some more water.
CPL one too.
Yeah. So.
Thank you so much. Yeah.
Part of it. I owe you.
Yeah, usually I have that in here. I don't. I apologize.
Yeah.
Are we ready?
Yes.
I'm ready.
All right, back on the record with the Harris matter. Any luck, Ms. Alter?
Yes, Your Honor. So under Michigan Rule of Evidence 902, what was presented today is not a self-authenticating document. If it had a seal and was certified, that would be admissible under the rules of evidence, which apply at the preliminary exam. Also in that vein, MCL 766.11b also says that the rules of evidence apply with the exception of certified records of conviction. This is not a certified record of conviction. If this were to come in under, say, 901, it would need to be properly authenticated by, say, the clerk of the courtroom in which Mr. Harris was or was not convicted, and we don't have that today.
Ms. Famali?
Judge, this isn't being introduced as a certified conviction. This is being introduced into evidence as a document that the officer has in part of his possession as part of this case. He's the officer in charge. It's not as a certified conviction or anything like that. He can testify as to what he wants, but it's not being introduced as a certified conviction. It's just being introduced.
Then why do you want it?
It's being introduced into evidence, and it will be used to show, what it will be used to show is that the defendant has a previous conviction, but it's not being introduced as a certified conviction.
But
Also,
counsel just said those, what she just read clearly says that if you want to establish in a court of law a prior conviction, you need that or an authenticated copy, which would mean certified court clerk.
And also, Your Honor, doesn't get over the hearsay issue. This is about
Also-
authenticating, but we also have the hearsay issue.
Also, the court can take judicial notice over the defendant's previous history. It's in their records.
I don't think I can.
Yeah,
Give me some authority. Give me some authority.
I could use the business record exception.
Not according to what she just read to me.
That's it.
It's got to be a certified copy.
Can I see a copy of what you printed? Judge, may I have an opportunity
Sure.
to review what he's saying?
So Michigan Rule of Evidence 902. So if you introduce this on its own, it needs to be authenticated.
Take a minute, look at it.
So Judge, all this rule states is that the following evidence are self-authenticating, and it has a list of documents. It doesn't say that in order for that, it has to be a certified record of actions from the court for it to be introduced of the defendant's previous history. There's nothing that says that on this. This is just a rule that states the following items of evidence are self-authenticating, and no extrinsic evidence of authenticity is required. And it has a list of things. This doesn't, just because it has certified copy of public records, doesn't mean that it's not. So she's saying that because this is on the list, it doesn't mean we can introduce that. That's not what this is saying. All this is saying is if it's a certified copy of
I understand your argument. I understand your argument. That doesn't, your argument is that explains what a self-authenticating document is, but doesn't say there's not another way to get the evidence into evidence.
Correct.
Or the information into evidence.
Correct.
Okay. Response?
So what, I mean, I'm guessing what would that way be to get that into evidence? I'm just,
Well, I know what his way is going to be.
what's,
Talk about
so
it.
we're all on the same
Talk about a
page.
document that's normally kept in the everyday courses of business and like any other business record. That's where he's going. Am I right?
Correct.
One moment, Your Honor.
Sure.
Oh, may do it right after this.
Your Honor, I'm ready whenever you are.
Okay, go ahead.
So if it is APA Mohammed's intent to admit this under the business records exception, which I believe is Michigan Rule of Evidence 8036, even if it's established that this is a record kept in the course of business, the rule still requires that the conditions are shown by the testimony of the custodian or another qualified witness permitting the certification. So somebody would need to testify that this is a record kept in the normal course of business. Now, I understand that this officer at some point viewed the lien somebody else ran, but we're talking about what happened in the court of law. And that officer was not in the court of law at the time Mr. Harris was or was not convicted.
And Judge, may I respectfully respond?
Sure.
The individual that has possession of these items, if he can testify to being that individual, it's contained in his jacket. He's the OIC. It's not just an officer. He formed all of this investigation. He created the investigator's report. He put together this case.
Here's where I think the disconnect is. Everything she's saying that has to be done guards against an inaccurate lien report. Somebody from the convicting court testifies, yeah, we checked our records, and what that says happened on lien, it happened in our records as well. Or it's a certified copy of a lien report, which is lien saying, yeah, we checked, this is good stuff. Would you agree with me?
More or less, Your Honor, we're talking about reliability and authenticity.
That's what I mean. That's what I'm saying. The problem, Mr. Muhammad, is if I buy your arguments, all we've got is Rice, who works with lien reports all the time, saying, yeah, that's the way the lien reports look to me. But he's got no way of checking whether or not that's an accurate lien report or not. He can say it doesn't look like it's been forged, but lien's a system where mistakes can be made as well. Any system can have mistakes. Go ahead. I'm having fun here. You want?
Judge, this lien was printed from the Romulus Police Department.
That doesn't help me. It doesn't help me because garbage in, garbage out. If lien has bad info, they get bad info when they ask lien what they've got.
I understand.
The certified record or certification from the convicting court say that lien information is not bad info.
Judge, respectfully, defense counsel had an opportunity to search and stuff.
I'm doing a search warrant. Do you need a minute? Take a minute. Take a minute. I'm trying to keep other cops working.
Because we're just gonna have them print out the original. Oh, I see.
Original what?
The lien, he's gonna go out to his car.
I don't think that's going to do a thing for you.
But this is the officer printing it.
It doesn't matter. It's got to be a certified copy. That's what I'm saying. I think it's got to be a certified copy.
And to be fair, Your Honor, as well, like I was not counsel of record on this previous case. We don't know if it was pled out. We don't know if there was some sort of reduction. We don't know if it went to trial. I don't know.
I think there's a reason we always use a certified copy of a conviction at this stage of the game.
Judge,
I'm ruling against you, brother.
I hear
Appeal me, educate me. I'm all for that. But no, if I'm wrong, I want to know it.
It's just we're not determining guilt at this stage.
Yeah, you are. You're determining the guilt of the felony to establish your felony firearm.
No, we're determining whether or not there's probable cause for a crime being committed.
It's an element that you have to convince me of now to get past preliminary exam stage on a felony firearm. I think there's a reason we always, at this stage in the game, we always have a certified conviction record admitted.
Well, I did try at least to introduce into evidence the document that he testified to, and that document.
And I'm shooting you down. I'm shooting you down. I think it's got to be a certified conviction record, or it's got to be something from the convicting court. The court record that says on such and such a date, such and such happens.
Well, Judge, in that case, then warrants shouldn't be signed because then a warrant prosecutor doesn't review the defendant's. We don't get.
There's a difference between approving a warrant and proving probable cause at exam.
I think the standard is higher when signing.
I've just disagreed with you. So now the argument time is done. Move forward with what you've got. And once again, appeal me, prove me wrong. I'm happy to be educated. I like your passion, but it takes more than your passion. Just wait.
sign and send for some reason. So I'm gonna send you, to print it or do a hard copy. So I'm saying I'm gonna do a scan it back. So it's not. Yeah. But if I remember right, it's something that I'll get rid of the same thing. It's asking me to confirm my.
Yeah, go ahead. You're still recording, right? All right, can we move forward? All right, what's next?
I mean, unless I can continue with my question with the OIC, who's gonna testify to the previous conviction that was on the lien?
It's not gonna get you past the hurdle, I don't think. Well, I'm just telling you, it's not gonna get you past the hurdle.
I would still.
But you
like
got
to
other
move-
charges on here than felony firearm.
I apologize. I didn't catch that.
I said, there's other stuff on, I mean, I got a 7-count complaint. They're not all felony firearm. Any witnesses?
No, Your Honor.
I'm ready for argument.
Judge, the people would move for a binominal. I believe the testimony by Detective Otter showed to this court and to myself that there was reasonable suspicion for the stop of the individual. In this case, it was when Detective Otter observed the defendant in front of I think liquor store or something along those lines, and he observed the butt of a gun, which he was unsure of.
You're doing it again.
I understand.
You know what you're doing?
Yes, I'm going over the facts.
You're telling me everything I
Somewhere.
just heard.
Yeah, and I do that for the record. However, okay, so I will move for a bind over on all counts in reserve argument.
Thank you, counsel.
Your Honor, as you know, this is a 7-count indictment here that we have. And defense objects to the bind over on all counts. And I'd like to address the first 4 counts that we've been recently discussing, which is the FIP firearm, the FIP ammo, and then the accompanying felony firearms. Because there has been no certified conviction record admitted at this exam, I'm moving to dismiss on all 4 of those counts because there's just nothing that authenticates these records that show that Mr. Harris was previously convicted of a felony and was not allowed to possess either a firearm or ammunition. So then the accompanying felony firearm counts should be dismissed as well. But furthermore, Your Honor, the gun, the ammunition, and the alleged drugs should be suppressed on 4th Amendment grounds here. Police lacked probable cause to seize Mr. Harris that day in the parking lot. As you heard the testimony from Sergeant Otter, he made the decision to stop the vehicle based on very limited information. Based on his testimony, this is what he says. He claims he saw a person with a black object in his pocket. He says he was unsure of what that object was. He even noted that in his report. And honestly, Your Honor, it could have been anything. A black object can cover a phone, a wallet. I won't belabor the point, but he said he was unsure that this was contraband. So this is not probable cause that a crime is being committed. Despite this, he orders the driver to turn up the car, seizing all of the occupants in the car, including Mr. Harris. And he said that these people were not free to leave. Mr. Harris was brought out of the vehicle and then he was immediately frisked. We then go to Officer Koziara, who says he did the pat down based on the information relayed by Sergeant Otter. Terry pat downs require that someone is both armed and dangerous, and it's reasonable, articulated suspicion that someone is both armed and dangerous. Koziara, when he saw Mr. Harris get out of the car, did not immediately see the weapon. He testifies he saw the butt of the gun inside of the pocket, but that is still not reasonable suspicion that he is both armed and dangerous. There was no testimony suggesting that Mr. Harris was dangerous up until this point. He was also unaware if he was a convicted felon or had any sort of criminal history that prohibited him from having a gun. And as we know, a lien search was not conducted by either of the testifying officers at this time. But then, Your Honor, this is where the stuff gets very troubling, because Officer Kosiara does a pat down for weapons. Fine. He does another pat down for weapons to make sure there's nothing else contained on Mr. Harris. Also fine. Now we know he's not armed and dangerous. And yet, Officer Kosiara moves the location of Mr. Harris and he performs another search. And this time, Your Honor, the search is not conducted with additional probable cause or reasonable suspicion. It's already been determined he had a gun on him. It's confiscated. The end. That's it. So the reason for why he needed to be patted down again, and not just patted down, but searched. This officer says he put his hand inside the left-hand pocket to retrieve a baggie. That is a search without probable cause, and whatever was in that bag should be suppressed on Fourth Amendment grounds because it is the fruit of the poisonous tree. For that, if the alleged drugs are suppressed under the Fourth Amendment, then the accompanying felony firearm that is attached to that charge should also be suppressed and dismissed. So for all of those reasons, Your Honor, defense objects to the bind over and asks that all 7 counts be dismissed. Thank you.
Mr. Muhammad.
Judge, in regard to the CCW, I think it happened twice in this case, in my opinion. I think the first time was when Detective Otter observed the individual about to enter a liquor store, and he stated that he was unsure, is what he said, but he what appeared to be was the butt of a gun, and I believe that established reasonable suspicion. And he confirmed that suspicion when he found the individual inside of the vehicle with the gun concealed and the butt still sticking out. Well, what may have not been him, I think Kosiara recovered it, but I believe they said it was in a pocket or concealed. It was not just concealed on his person, it was also concealed in the vehicle. That individual failed to produce a CPL license. Part of carrying a gun lawfully is getting a CPL license. Defendant didn't do that in this case. He also had an affirmative duty to disclose to an officer that he had it when he made contact with those individuals. He failed to do that as well. Furthermore, the testimony by Sergeant Otter was that contacted dispatch, and he learned based off of his investigation that the defendant did not have a CPL license. So there was 3 steps that, in my opinion, could have been resolved this entire situation, and because it wasn't, that's why we're here. That's for the carrying concealed. In regard to the 2 FIPs and the 2 felony firearms, there is a total of 3 felony firearms. But in regard to count 2 and count 3 and count 5 and count 6, which attach, I believe that the court can take judicial notice over their own records in regard to the defendant's previous conviction in 2020, where it shows that he was pled guilty to home invasion. This is a specified felony. He's not allowed to carry firearm for 5 years at a minimum. And even after that 5 years, that individual is supposed to go in front of a gun committee.
Let me stop you. Where was that conviction out of? Wasn't this court? No. Okay, so you said I could take judicial notice of the court's own records. They wouldn't be my records.
Oh, I apologize. I'm
Okay,
assuming
go
that
ahead.
you guys have a copy of the defendant's previous CCH.
Not as part of our court file.
In the file, you guys don't?
I don't think so, not normally. And besides, I got a lot of stuff in files that don't end up admitted evidence. Move on. That's
Okay.
You're losing that one.
Okay.
You're losing the felony firearm.
Okay.
Move on. You still got 3 counts to talk about.
And then in regard to the possession, so the MSP lab report that I introduced shows that the drugs that were recovered from the individual, the defendant.
That's not our argument. Our argument is about it was an illegal search.
I understand. So the stop was not only based off of Sergeant Otter seeing the gun. The guy was also drunk. So based on the testimony, that they observed an individual who appeared to be intoxicated And this individual was also in possession of a firearm. So even if we were to throw out the CCW, still in possession of a firearm, and the officers testified, or at least Sergeant Otter testified that that individual appeared intoxicated. Now, Officer Cozier responds to assist Sergeant Otter. And then he knows that this is in regard to a firearm. Firearm is a safety concern for officers, so he just conducted a pat down. And upon observing that firearm and recovering that firearm, that individual, like I stated earlier, never disclosed the CPL, so that individual was placed under arrest. They testified that there was multiple reasons. One, the CCW. Two, he was in possession of a firearm while under the influence. So if we're just letting drunk guys walk around with guns, and it's a safety concern. Who knows? Maybe he pulls the trigger. Maybe he finds another. We don't know. So it's part of an officer's duty to conduct a pat down and confirm for safety. Also, the individual is being placed under arrest. So during that, then that's when the officer recovered also narcotics or drugs, cocaine to be specific in this case. So I believe there was probable cause for all of it. I believe that this case should move forward, and I would move for a bind over. Also, in regard, if you were to dismiss count 2 and 3 and 5 and 6, count 7 still attaches to the possession of drugs. So I would move for a bind over on all of that. Thank you. And also, last thing that I would like to state is, you know, this is just a hearing where we're determining whether or not there's probable cause of a crime to exist, and that this individual committed that crime. And I believe the testimony reflects that today. Thank you.
Thank you. You want another shot at me?
Sure,
Go ahead.
Your Honor. I won't belabor any points. I think make the record clear. It was the testimony of, I believe, Sergeant Otter, that he said he noticed that Mr. Harris was intoxicated, but that wasn't the basis for initially approaching him. If it was, he would have approached him.
That's speculation.
Well,
she doesn't know what
it is.
So, but what I'm saying is that intoxication, public intoxication, shouldn't be the basis for reasonable suspicion or probable cause to search someone, even if it was, Your Honor. Let's say it was. To do a Terry frisk, which is what was performed here, requires reasonable suspicion someone is armed and dangerous. Intoxication does not equal dangerous. Intoxication does not equal armed. That also, so that's for the CCW count. For the controlled substances count, that doesn't get over the hurdle of the fact that it had whatever reasonable suspicion officers had was resolved when they recovered the firearm and did 2 pat downs. The third search, which was a full-throated search under the Fourth Amendment, didn't have probable cause that a crime was being committed, and yet Officer Koziara continued to search this person, stick his hands inside of his pockets without a warrant, and recovered a substance that should be suppressed under the Fourth Amendment. Thank you.
Thank you both. All right, just so we're clear, Mr. Mohammed, counts 2, 3, 4, 5, and 6 are all related to prior conviction. Those are
no. Just count 2, 3, 5, and 6, not 4.
Oh, I'm sorry.
4
You're
is
right.
possession of
2, 3, 5, and 6.
Correct.
Right. So that leaves 1 CCW, 4 possession of cocaine, and 7 the felony firearm tied to the cocaine. We're all clear?
Correct.
All right. On those, I'm binding over. Sergeant Otter said that he saw what he thought could have been the butt of a firearm sticking out of Mr. Harris's pocket. He also said he took video on his cell phone where he could then zoom in, and then it was clear to him that it was a firearm. I think that is certainly reasonable cause, reasonable suspicion, which makes it a valid Terry stop. The thing that's lacking here is nobody asked either one of the officers at what point Mr. Harris became an arrestee. Because once he was arrested, the full body search was okay at that point. Probable cause hearing, I'm binding over 1, 4, and 7. AOI date is going to be the 12th at 9. Anything need to be made clear for the record?
Nothing from the people. Thank you.
Nothing.
Anything as to bond, or should we leave it as is? Well, we'll leave it as is. Bond continued. Good luck downtown, Mr. Harris. Thank you.
Yes. Yeah, I'll send it right